Okay, this, I hit continue?
Yes. Oh, yeah. Yes, because you're being recorded.
Okay. I see Stuart. Francesca, our new board clerk extraordinaire. Who's here?
So far we have, Paul Dossert and Stuart Helpner both on the line.
Okay, on my little screen I don't see Paul, but say something, Paul. Okay. I'm going to step away for a minute and call Mayor Wells and see if okay. Paul, I don't see you on my screen. Say something.
I don't know if we can hear you, sir.
Okay. Oh, Paul, can you hear? Do a sound check. Okay. Okay. Stuart, can you hear me? Wave your hand. Okay. All right, Stuart can hear me. Paul, can you hear me? Wave your hand. Okay, Paul is not getting the audio, or he's muted, or I'm muted with him or something.
He's not muted. Maybe he has his speakers turned down or off.
Paul, can you hear me? Okay, call Paul too. Sorry if the public is looking at this. We're trying to work this through.
Mr. Dostart, this is Tessa. If you could log off and log back on, please, maybe that will fix your audio.
Who are you talking to, Tessa? Paul. Yeah, he can't hear us?
He's not hearing. He can't hear us.
Yeah, he can't hear us.
Okay, let me call him.
He's not getting any audio on his end.
I'm not seeing Bob on the participant list either.
Okay. No, Bob Monson. Is Bob?
He's attendee also.
Okay.
Yes, sir.
Paul, we're trying to talk to you, and it sounds like your audio is not working. So,
Okay. Let me try and see if I can do anything.
So Bill Wells is 292.
Okay. Whoa, I just figured out. I had it on mute, Bill.
okay. Can you hear us, Paul?
Yeah, Paul can hear 5 by 5.
All right.
You can hear me.
Okay. Stuart, you can hear. I don't see Bob on my screen. Bob, if you can hear, say something.
Hey, Bill Baber, it's Bill Wells here.
Okay, good. I think the only one I haven't gotten audio confirmation is Bob Monson. Can somebody try?
Bill, can you hear me?
Yes, Bill Wells. Bill Baber can hear you.
Great. I'll mute myself and get on when I need
Okay.
to talk.
Okay, can you hear me?
I'm just trying to have Bob, and if he's here, then we're rolling.
Can you hear me, Bill?
Gotcha. Okay. Then thank you to the Audit Committee for Friday, September 11th. Are we recording?
Yes, we are.
Okay, all 5 members are present. The first item is public comment, communications member comments. I'm assuming that's non-agenda public comments, right? Okay, do we have any, Tessa? I'm sorry, Francesca.
Quite all right. I do not see any hands raised for public comment at this time.
Okay, then item 2 is the main event, salaries and compensation. Excuse me?
Can I make a member comment?
Oh, certainly. Go ahead, Stuart.
Thank you, Chair Baber. Yeah, I got involved with SANDAG, a member of the ITOC, nearly 7 years ago because of how strongly I believed in its importance to our region. And I've learned to appreciate that even more over time. In 2016, I had a front row seat to the circumstances of not just revenue forecast errors, but some very questionable governance issues that made me wonder, should I ask more questions at ITOC meetings? Should I have been a little less trusting? And those governance issues are why SANDAG now has this audit committee. So for the sake of governance oversight responsibility, which is entrusted to us by the California State Legislature, in addition to getting into the substance and findings of this audit report, I feel compelled to raise some governance issues around the process surrounding today's meeting And I do so making no judgment and frankly with no pleasure. First, the placement of the audit report to be discussed on our committee's website is behind some 300 pages of other material, as if someone joked me we're trying to bury the report. That's simply unprecedented in my experience. Second, the extent of the redaction of substantive material information in the auditor's report, especially relating to allegations of, quote, undue influence, unquote.
Hey, Stuart, this is sort of the subject of the meeting. Usually member comments are things unrelated to the subject of the meeting.
Well, this is about the process, so if you feel it's better done elsewhere, I'm happy to do that. But
Yes, let's get into the meeting, and you can raise those issues. Also because Bob has a hard 2:30 drop, and I want to make sure we do as much as possible to keep him in the decision-making because he's got to go, okay?
Okay, well then let me suffice by saying I think there's some very serious governance process issues that we need to address that are somewhat related, they're obviously related to, but somewhat separate from the audit findings.
Yes, fair enough. There's definitely been some technical difficulties on that. Okay, so
Thanks.
on,
Thank you, Bill.
on salaries and compensation performance and compliance audit, number 2, the audit committee is asked to discuss the salaries and compensation performance and compliance audit, management responses and associated materials, and consider a recommendation to the board of directors for action. So our mission today is to give the board of directors a recommendation, and we can factor in everything from the OIPA report, everything from management's response, everything from our attorneys, everything from our outside counsel. So in order to let everyone have a chance to speak, but remember the mission is to make a recommendation to the full board. We're going to let management go first. I think that's what OIPA requested. And then we'll have OIPA go second, and then we're going to have our outside counsel, Art, go third, and then everyone will have a time to rebut. So I'm going to start the clock at 20-minute presentations for each of them. And then after we get the 20-minute presentations, and you don't have to use all your time, management, Art, or OIPA, then we'll have questions to the 3 presenters, then from the audit committee. Then the audit committee will deliberate on what recommendation can make to the full board. Okay? Everybody good with the plan? Okay, so management goes first, and I got to look at my tech person. Who do you switch on to let management start their presentation? Francesca.
Production team, are you able to assist?
It's Julie. I was told Julie's presenting, but give her the screen so she commands the field there. Okay.
Okay.
There you are. Hi, Julie. Okay.
Hi. All right, well, let me get going here. So speaking for management, I'd like to say we're really distressed at the direction this audit has taken, and we want to be very clear from the beginning that management has acted within its authority and did not misuse any public funds. We look forward to discussing this with you further today. Since management is speaking first, it seemed appropriate for me to start this off by discussing how we got here. So OIPA's audit plan, as approved last spring, shows that it intended to conduct a compensation audit as a third-tier priority in fiscal year 2021. However, when the board was considering the FY21 budget in May, a couple of board members asked for a review of employee compensation, and this audit began soon after that. There's no record of the board taking a vote on that particular request or requesting that the audit be performed on a particular timeline. The draft audit was issued to this committee and management on July 30th. Management immediately noted that the draft contained language that could trigger litigation and that it disclosed information that could be tied to the performance of particular employees. It also immediately noted some of the audit's conclusions were confusingly based on laws that don't apply to SANDAG. The audit committee requested a closed session to obtain legal advice from outside counsel, and that was held on August 12th. Management proceeded with responding to the draft audit and did so on August 14th. A document called the final audit was unexpectedly sent to the full board of directors on August 26th. Renee, Public Law Group, who was hired by the Audit Committee, provided the committee with a legal opinion in closed session on August 28th. The committee directed that the opinion also be provided to OIPA and management. The Renee opinion was wholly consistent with points made in management's response to the draft audit. Based on the significant modifications between the draft and final audit, the opinion of the Renee Public Law Group, and management's belief that there would be another set of revisions to the final audit, management prepared a revised response that it had planned to provide to OIPA and the Audit Committee by September 4th. As a point of clarification, management's revised response was meant to be read in coordination with the revised final audit, so that a reader would not be confused by remarks in management's original response that did not align with the revised final audit. So now I want to pause and speak for a few minutes about the redactions management has made to the various documents posted on its website for this meeting. It is reasonable for Sandag employees to expect privacy with regard to their performance and compensation and promotion decisions associated with their performance. That is why employee performance information is exempt from disclosure under Government Code Section 6254, subsection C of the Public Records Act, when the invasion of privacy is unwarranted. There were less intrusive ways to issue the audit findings without including information that could be used to identify particular employees. Aggregated and anonymized information could have been used, or both a public and non-public version of the report could have been issued. This would have been a better way to balance the interests of disclosure and privacy at play here, and management feels strongly that this should have been done on this audit and should be the methodology used for future audits. GAGAS, the auditing standards that are the basis for Sandag audits per law and board policy, recognizes the potential need to exclude confidential or sensitive information in an audit report. Specifically, it identifies privacy concerns as a basis to justify the exclusion of certain information from a publicly available or widely distributed report. In such a circumstance, GAGAS calls for the omissions to be noted and that they not distort the audit results or conceal improper or illegal practices, and that the omitted sensitive information be communicated to governing officials by another means. In this case, the redacted information is directly tied to employee privacy concerns, and management believes the exclusion of personally identifying employee information in no way distorts the audit results or conceals any practice. And unredacted reports have been provided to the Audit Committee. In addition, the audit contains findings of breach of fiduciary duty and other allegations of wrongdoing by employees, which have not yet been investigated. As pointed out in the response, interpretation of laws concerning breach, fraud, and employee wrongdoing should be conducted by attorneys who are qualified to interpret the law. And until a full investigation of any potential wrongdoing occurs, putting out information that could be incorrect could lead to claims by persons both within and outside the agency. It is for this reason that several closed sessions were held with the Audit Committee previous to this open session. Although the audit documents were marked as confidential, the documents were disseminated to dozens of people on August 26th, making a leak of the documents almost inevitable. And as expected, a leak occurred. And then, on or about September 4th, the audit was disseminated even more widely on the grounds that the redacted versions posted by Sandag were misleading and in violation of government auditing standards. To be clear, the only modifications to any of the audit documents or responses by management have been to redact information that should be kept confidential, not to distort the truth. It would have been easier for management to just throw up its hands and give up on its standards of protecting staff privacy and the agency from unwarranted litigation after unredacted versions started popping up in journalist articles on August 31st. Redacting records is time-consuming and cumbersome, and doing it after a journalist has unexpectedly published an article and there's pressure to provide information to journalists and the public is even more difficult. In fact, that time crunch led to mistakes in the redactions and in the methods used to make them. Management had to reach out to some people and apologize for that mistake. Despite the extra effort needed and the time pressure, management will continue to make the effort to redact information that should not be disclosed. This is being done in keeping with the decisions made previously that the audit could trigger unwarranted litigation and that it is unnecessarily infringing on employee privacy. The redactions made by management were made sparingly and are entirely in keeping with the things I've just described. No effort is being made to distort the audit report or management's responses. I will now move on to addressing the specific findings and recommendations in the final audit. To repeat though, there has been no misuse of public funds. All bonuses and employment contract terms have been fair and reasonable, and all severance payments were appropriate and avoided potential litigation that could have been much more costly. The final audit contains 10 findings and 36 recommendations for consideration. Management strongly disagrees with many of the findings as they are written, but does agree most of the recommendations should be undertaken as part of the agency's commitment to continual improvement. Actions to start implementing several of the recommendations already have been initiated. Some may require further consideration of the board, while others will be contemplated by management and they have been determined to be unwarranted at this point. I'm going to go through the findings and recommendations in a summary form. The differences between the draft and final audit on finding 1 are significant, but the final audit still misses the mark. Management agrees that governance of Sandag is the responsibility of the board and committee members. The legislature has granted the board that responsibility in various statutes, including Senate Bill 1703, which went into effect in 2003 and created a new agency, albeit under the agency's former name. The legislature also granted authority directly to the executive director for administrative matters within Senate Bill 1703. Although the bylaws and Board Policy 17 repeat and add to that delegation of responsibility, it does not change the fact that the executive director's authority over the administrative matters of the agency stems from SB 1703 and the legislature, not the board. As discussed in management's responses, the administrative rules and regulations were superseded in 2006 with knowledge and approval from the board, and they are no longer in effect. Employment matters at the agency are currently covered by a 260-page employee handbook. Sandag employees are not subject to the Civil Service Act requirements that apply to state employees. The board, on its own volition or at management's behest, has never improperly delegated anything, and the board is not required by law to take on the task of setting all administrative policies for the agency. The law is clear that the board can delegate authority to create administrative policies concerning personnel. There just needs to be safeguards in place. Applicable employment laws, board policies, and the board's control over the budget provide those safeguards. The board is responsible for setting public policy, and management is responsible for creating administrative policies and processes to convert the public policies into action. Overseeing the policies and procedures for hiring, promoting, compensating, and terminating employees is a matter of administrative policy, not public policy. Management recommends that in response to audit recommendations 1 and 2 for finding 1, that information be brought to the board at a later date to decide if it wants to revisit the bylaws and board policies. Management recommends that the recommendation that the board hire another general counsel be rejected for the reasons described in the response. And as the 4th recommendation, Sandag employees already sign acknowledgements that they are aware of the policies that apply to them when they are hired. However, if the board directs it, Human Resources will obtain an acknowledgement every year. I will now move on to finding 2. The audits state that payments to 4 former employees who have left the agency are improper. There is no smoking gun here as portrayed by the audit reports. Instead, there are logical and documented explanations for why the payments were appropriate as part of a plan to reduce risk for the agency. For this finding, the information provided in the record shows that the employees in question had potential claims, that outside counsel with expertise in employment law was utilized to evaluate the potential claims and litigation costs, and management concluded the severance packages would be less likely to the agency due to those various risk factors. Additionally, Renee Public Law Group agreed as a matter of law that the severance payments were not an improper gift of public funds. Indeed, while the practice is a rarity at Sandag, use of severance agreements to avoid potential litigation makes sense under certain conditions, and it's not atypical in the public sector, as can be seen by the cases cited in the legal opinions on this topic. There are 3 recommendations under this finding in the audit. The first recommendation is a formal investigation into management's actions. This has basically already occurred with a determination in management's favor, as can be seen in the Renee Public Law Firm's opinion. There is 0 evidence that management's actions were improper. Management concurs with the other two audit recommendations under finding 2. Management recommends that the topic of whether to add provisions to board policies concerning severance payments for employees be discussed by the board as part of their annual review of board policies. In finding 3, the audits proclaim that a former employee was paid high dollar bonuses and salaries without justification. The lack of justification is based on the contention that the employee's performance evaluations were not fully completed or signed. The manager of that employee had unexpectedly retired from Sandag before completing the performance evaluation, and the employee kept their previous job functions plus most of those previously performed by their manager. Double duty, shall we say. This employee had a key role, and if they had chosen to leave, Sandag would have had a very difficult time maintaining its operations. As explained in the management responses, management spoke to the board chair at that time, Terry Sanat, to obtain advice on how to proceed. This is because the chair of the Sandag board has authority to provide general supervision over the board's affairs per Article 5, Section 1A of the bylaws. Chair Sanat authorized a series of bonuses and salary increases over the course of a year to encourage the employee doing double duty to stay and provide a reward for the extremely high level of effort being provided to the agency. Chair Sanat has provided a memo, which the audit committee has seen, explaining his actions and the justifications for the additional compensation. Former Chair Sanat provided his memo on the condition that it only be given to the committee and OIPA, as he said his memo concerned a confidential personnel matter. The memo establishes that he gave the authorizations and that he did so based on the need for the agency's work to continue seamlessly, to avoid any conflict of interest by having another employee make the compensation decisions, and because the additional pay was merited. The audit recommends that an investigation occur and that all authority for awarding salary increases and bonuses be withdrawn. Management does not recommend either of these courses of action. If requested by the board, the pay for performance program and board policies can be discussed at a future board meeting. Management does not recommend that the board consider adding clarity. Management does recommend that the board consider adding clarity about when the chair or vice chair can take actions that can be reported back to the board at their next meeting, similar to the method used for the executive director. Finding 4 alleges breach of fiduciary duty by management. Management is adamant that this finding is unfounded. Even if all the statements in the audit were true, the legal elements constituting breach of fiduciary duty are not present. Breach of fiduciary duty involves showing that the person with a fiduciary responsibility breached the trust of another by withholding pertinent information, misappropriating funds, abusing a position of influence, acting disloyally, or making misrepresentations. None of those things occurred here. Management believed it followed the correct course of action for approving special compensation and did not learn that CalPERS required a different process until earlier this year. The review conducted by CalPERS clarified the expected process, and the board was notified of the mistake in July. Management has already started taking steps to correct the error. There was no act of disloyalty, misrepresentation, misuse of funds, or withholding of information. There also was no intent to violate any requirements or any acts of self-interest. There was a mistake on how special compensation policies were approved, and it's being fixed. Therefore, management agrees with the first recommendation on this finding and is in the process of drafting a policy defining special compensation and its approval process, which will be brought to the board in the fall. As to the remaining recommendations, that management agendize salary and special compensations as an item separate from the budget, provide more information on employee salaries and benefits, and involve the board in conducting reconciliations of the compensation pool, management recommends that board direction be sought. If the board requests it, changes to the board policies can be made. Finding 5 concerns the adequacy of financial controls. Management does not agree that there was an intent to improperly allocate expenses to fringe benefits or overhead. Finance followed a practice that is used previously and that has been found appropriate by prior auditors. Management finds the recommendations for finding 5 helpful and plans to revisit its procedures, add controls, enhance training, and review and document the basis for the allocations. Management proposes to provide follow-up information to the board on these recommendations in an action plan that is under development. For finding 6, the audit states the annual productivity program has been mismanaged. lacks transparency, and that there's a disparity in the payment of bonuses to employees in prior fiscal years. What the audit does not explain is that Sandig has a merit-based compensation system that uses both merit increases and bonuses to reward employees who are performing well. Merit increases are what is primarily used at Sandig. They represent 80 to 90% of the productivity program's numbers. Pay increases support the agency's retention goals by ensuring employees' pay remains competitive. Bonuses also are used to reward employees, but only when superior performance in achieving goals has been demonstrated. In most cases, performance benefits are used to supplement merit increases or instead of merit increases when an employee is at or close to the top of their salary range. This practice supports fairness in the compensation program by ensuring the total reward provided to an employee is commensurate with their performance and contributions to the agency. All of the bonuses were documented, justified, and well-deserved. So the explanation for the disparity is this: not everyone gets a bonus because most people get a raise instead of a bonus. Management is in favor of keeping bonuses as a method of recognizing employees who have worked hard and either completed something exceptional or decided to stay at the agency even when they know they will not be eligible for a raise. Management recommends no changes. Management does agree, however, with the recommendations in the audit for improving documentation of the decision-making process associated with awarding bonuses and the reconciliation methods and procedures staff should follow for performance bonuses. This brings us to finding 7. The audit.
Julie, it's Bill. Can you hear me?
Yes.
We're trying to keep everybody close to 20 minutes. You have 2 more minutes left. How much time do you think you need to finish?
5 is probably good. Is that possible?
Okay, we'll give you 5 more minutes.
All right, thank you. So for finding 7, the audit states that Sandig's procedures and methodology for setting salary changes are inadequate. Management disagrees, and as discussed in the responses, Sandig hires experts to assist the agency in developing classification specifications and salary studies. Management is confident the entities used as a comparison to Sandig for purposes of setting salaries is appropriate. Management does agree to develop job duty statements as part of its action plan for following up on this audit, but does not recommend any changes to its current methods or procedures for salary setting. The audit next delves into whether the decision by management to make promotions as part of the reorganization were justified. The board hired Hassan Akrada rather than promoting from within to fill the executive director role because they wanted change. Now, no one can argue that Hassan has not brought change to Sandig. A highly qualified consultant firm was competitively procured by Sandig to assist Hassan. Sandig had not done a reorganization of staff since just after the consolidation in 2003. The agency has undergone a lot of change with regard to its responsibilities since 2003 and has new responsibilities on the horizon. The decision to increase the number of positions considered to be part of the executive team could lead the outsiders to believe the number of people involved in managing the agency have grown significantly more than they really have. And as explained in the response in attachment L, there are justifications for every change that has been made. Staff who were reclassified or promoted took on significantly more work, and the salaries are commensurate with market rates. Hassan has repeatedly stated that the audit findings have not caused him any doubt that he made the right decision. Management strongly opposes any action that would revert any of those decisions. Management is, however, very willing to work on improving the consistency and accuracy of agency documents. Finding 9 focuses on management's decision to appoint employees rather than competitively recruit. For many years, the employee handbook has allowed for appointments when it's in the best interest of the agency. The audit makes it appear that appointments are a common practice at Sandig, and they're actually not. Of the 375 positions filled at Sandig in the last 4 years, 311, or more than 80%, were filled via a competitive recruitment. It also should be noted that many other agencies like Sandig allow for appointments. Management believes its methods are fair and objective, and that using a competitive recruitment when there's an internal candidate that's clearly most qualified should be an option that's allowed. Also, Human Resources requested that the outside compensation consultant re-benchmark, and that was done to decide on the salaries. Management strenuously advises against taking the recommendation in the audit that the hiring decisions made as part of the reorganization be second guessed. Employees have signed binding employment contracts in good faith, and any action to undo them would likely result in negative consequences. The last finding in the audit implies that employees who have signed an at-will employment contract with Sandag were not given the choice to remain in their protected status. Each employee was offered a contract clearly describing the new terms and conditions of their employment, and each employee voluntarily chose to accept their offer. If any of the employees had rejected the offer, they would have kept their protected status. The audit fails to recognize that Sandag employees have more flexibility in their employment relationship with Sandag than what is available to employees working at other government entities. Sandag hires exceptional employees and evaluates them on a regular basis. Sandag has a merit system that relies on demonstrated performance, and Sandag has had at-will employees for many years. As stated in the response, 59% of Sandag staff are currently at will. It is troublesome to management that the audit infers at-will employment is improper or somehow denies advantages to the employees working for Sandag. The recommendations under this finding continue to rely on administrative rules and regulations that are not in effect. And furthermore, the recommendations imply the employee handbook is not in alignment with applicable laws. Management does not recommend any changes to the procedures currently in place in the employee handbook and believes the handbook provides significant protections. In closing, if the question is, did anyone act outside of their delegated authority? The answer is no. If the question is, were public funds misused? The answer is no. If the question is, did management make redactions to the audit documents and responses to hide wrongdoing? The answer is absolutely not. Management is very disappointed that the audit has become so controversial. We ask that the audit committee provide guidance on how to move forward so that future audits do not go down the path this one has. And we look forward to working with the committee and the board to further strengthen the policies and procedures of this organization. Thank you, Chair.
Okay, thank you, Julie. Next up is our OIPA, and Julie, we gave you 23 minutes, so we'll just give OIPA 25 minutes to start. So take it away, Mary.
Good afternoon, everybody. My name is Mary Koshmashrab. I am Sandag's independent performance auditor. I appreciate everyone taking the time out of their busy schedule to listen and be a part of this process today. Given the information that was already provided, rather than get into the weeds of all this, as the auditor have already provided a great deal of detail regarding the audit objective, the methodology, the findings and recommendations, all disclosed in detail in the final report. I would like to discuss two main takeaways from this audit that I believe are important for the public, the audit committee, and the board to thoroughly understand. After, I would like to provide some understanding of the audit process, professional standards that OPA must follow and are required to adhere to, and other professional obligations. First, and I believe most relevant, the auditors found that Sandag's executive director and management did not have proper delegated authority to make settlement agreements and take other actions as detailed in the report without the board's knowledge or approval, or in some cases, the approval of the general counsel. The auditors found that the documents provided by management and other corroborating evidence gathered by OPA did not support that the board delegated their authority to management or the executive director to independently carry out these actions identified in the report. Additionally, the auditor identified, based on our review, that Sandag has material weaknesses in system controls around various operations that require strengthening, including proper written policies and approved procedures, followed by written procedures to carry out and administer governing policies. Second, I think it's important to mention that in my 25 years of auditing government at all levels of government and from an internal and external perspective, that I have never experienced this degree of interference and impairment of independence from a government agency by their management and their audit committee chair. The independent performance auditor's position was legislatively created as a result of Sandag's 2016 disruption that involves several of these same executive level positions that are now part of the interference that my office is experiencing, including Julie Wiley, who is the Director of Contracts and Grants Office, who spoke on management's behalf today regarding a salaries and benefit audit. I think it is important to make clear to the public that the position of the IPA and this office was created as a result of AB 805, and its main purpose was to ensure that this office would be independent and free from interference by management. Sadly, this has not occurred. With that said, I would like to provide the public and the audit committee with some understanding of the audit process from an auditor's perspective, not from an attorney's view. I think that it's important for people to understand that this is a very intense, well-defined process that must be adhered to by professional auditors. Sandag's Office of the Independent Performance Auditor, referred to as OPA, began the Salaries and Compensation and Performance Compliance Audit in April of 2020. The authority to complete the audit was provided and voted on by the Board of Directors and approved by the Audit Committee in an approved audit plan. In addition, the OPA was directed by the full board to complete this audit by August 2020. During a board meeting, OPA was asked what the timeline would be, and based on OPA's timeline, we provided August 2020 as a plausible date. In accordance with Assembly Bill 805, Sandag's Board Policy 39, and as the independent performance auditor, the audit was conducted in accordance with generally accepted government auditing standards referred to as GAGAS. As required by GAGAS, the audit process followed by OPA included inquiring with Sandag's management and staff to gain an understanding, requesting significant and corroborating supporting documentation or documenting a lack thereof, interviewing staff, performing analysis and substantive testing, which is otherwise known as an auditor's fieldwork process. At the completion of the fieldwork and taking into account other relative factors, the OPA used the work performed to develop a confidential draft audit report. It should be noted that under AB 805, Sandag's management is required to provide all documents to support and that were requested by the auditor to explain or substantiate concerning items in which the auditor was seeking information. Once a draft audit report was completed, the OPA met with the executive director and management in a formal documented audit exit conference to provide the draft audit report, discuss the findings and recommendations within the report. After, OPA informed management that the draft report is subject to deliberative process and may be revised based on additional supporting documentation and information provided. The OPA then provided management with sufficient time to review the draft audit report, provide additional supporting documentation, seek further understanding from auditors, and provide a written response titled Management's Response. In this case, management was given 11 business days. After the auditors received the management's response and the additional documentation, the auditors determined that the draft report required minimal revisions. Also, at the request of an audit committee member, the tone of the report was lowered while ensuring that the findings remained intact. Thereafter, the report was issued as final. Also in accordance with GAGAS and Board Policy 39, if there are material findings, impairment, hindrances, or interference with management or an audit committee, the auditor is required to report it to the governing board. In this case, the governing board is Sandag's Board of Directors. This action was taken in several emails prior to the release of the final report, and again on August 26th and 27th when the final report was issued. After OPA considered the audit committee's contracted attorney's final opinion that was provided to OPA on August 31st, and Sandag's contracted attorney after the fact opinions provided to OPA on August 27th, in keeping with our commitment to the audit committee. It should be noted that the final unrevised report originally issued on August 26th and reissued as unchanged again to the board on September 2nd was officially issued as final report by the independent performance auditor, which is the only official body that can issue a report final. To continue the audit process and matters around an auditor's work product, including the auditor's draft report, and in regard to Sandag and the audit committee chair's posted items, an auditor's confidential report is not obtainable through the California Public Records Act because it is a work product of the auditors, and until the auditor receives a management's response in addition to additional documentation, if any is provided, the report may be revised. This is very typical in an audit process. The draft document, if provided to the public, may contain information that would be unclear, misunderstood, or incomplete, which is why it is not obtainable by the public request. I would like it on record that note that Sandag's management, at the direction of the audit committee chair, included the OPA's confidential as marked work product in today's agenda package. In addition, it should be noted that the document was manipulated by Sandag's management and included deletions and redactions. It should further be noted that the final auditor's report on salaries and compensation compliance and performance audit and management's official response that stands alone as required by GAGAS has not, as of yet, been provided to the public and posted to the Sandag website, as required under both AB 805 and Board Policy 39. Further, the documents posted to Sandag's website for today's agenda was not docketed by OPA's committee liaison, which is a standard practice at Sandag. Additionally, the 406 plus pages that have been docketed are not OPA's final report or work product, as management has manipulated, deleted, redacted information that in parts are OPA's work product, but no longer stand alone or are structurally within the guidelines of GAGAS. The documents posted as agenda items to Sandag's website includes the following: a revised management's response that is addressed to me, the independent performance auditor, dated September 2nd, after the final report, which is August 26th, and the document was never received or provided to me as the IPA and as addressed. The auditor's work product, that is, as marked, a confidential draft that should not have been shared and has been also manipulated and redacted. Please note, redactions include dates, dollar amounts, and official titles that are not confidential in nature. Layers of other documents that have not been provided or reviewed by OPA, an attorney-client privilege document that was provided after the fact, attorney's opinions, assumptions, and assertions that lack any basis or evidence and in fact are conflicting with the supporting documentation that was previously provided to OPA. Numerous pages of previous board meetings and a letter that was currently or recently drafted by the previous chair of the board of directors and considered by OPA as more after the fact created documentation. And OPA's final report on page 300 that was issued to the board of directors on August 26th that has been defaced, manipulated, redacted, and in parts deleted completely by management, including some recommendations and management's original response that was dated August 14th. That has been completely deleted. In addition to the 406 plus pages of this agenda document, yesterday, less than 24 hours before this scheduled special meeting, I was informed that Sandag's management and the audit committee had added an additional document that was provided by their attorneys. This document was provided to OPA during the last hours and will not be considered by OPA, as OPA was not provided reasonable amount of time to review and consider any impact that it might have on the audit, in addition to the audit being finalized. However, it really should be noted that the document, in that document, the attorney makes a stated assumption that documents considered that might provide the executive director delegated authority was previously adopted by the board. OPA would like to confirm that management provided document to OPA that can confirm that such documents have in fact not properly been discussed or adopted by the board of directors. OPA would like to point out that this incomplete and manipulated inclusions of portions of OPA's final report is not OPA's work product. It should also be noted and concerning that this report provided has been redacted for dollar amounts, position titles, dates, and percentages that are not confidential in nature. Further, management's response that was provided to OPA has been fully deleted, as well as other parts of the report, making the report completely inaccurate, deceiving, and confusing to the public. I made several requests to the board and to the audit committee chair that this posting be removed, or at minimal that OPA's official report be posted as a separate agenda item and management's 406 plus pages be included as a separate item, and that SANDAG follows their normal protocols. My requests have been ignored. In fact, during an executive team meeting held with SANDAG's executive director and leadership team, both senior leadership and the executive director stated that they were in fact directed by the chair of the audit committee to docket the documents provided, acknowledging that the documents provided was not a common practice. Therefore, having been unsuccessful at all attempts to work with management and follow appropriate protocols, as the independent performance auditor, I am formally requesting that the audit committee officially release and post the full and complete unredacted final report with the original management's response dated August 14th. To repeat, the information that was redacted is not confidential in nature and does not pose a legal risk to this agency. The redacted information are titles, dates, and dollar amounts, and are not subject to confidential handling. In fact, more description and details, including names, dates, dollar amounts, have been publicly reported by the media in the past several days and during the period that these actions actually occurred. Management claims made in the agenda item stating that including information such as titles, dates, and percentages would bring risk to the agency is taken by OPA as more excuses to cover and hinder the audit process and the report. For example, when the city auditor issues a report that includes discussion of the mayor, the title of the mayor is not removed, yet there is only one mayor for that city at any given period. This would be the same situation in regard to OPA's report. OPA requested in an email yesterday to the chair of the board that the audit committee chair recuse himself from today's meeting, as the chair of the audit committee has been implicated in hindrance and impairment of OPA's independence. Further, as recommended in the final report, OPA continues to recommend strongly that the board perform an additional investigation. This investigation should be performed by an independent board-selected professional in the field of auditing and fraud investigation, and not by an attorney that expresses opinions on after-the-fact assertions with no factual basis or evidence to support such assertions. Because the agenda items posted do not represent the work product of OPA, the auditors are unable to respond in detail to the said documents, as portions of the auditor's work product have been included yet manipulated. If the audit committee would like to ask questions regarding general information, and myself and my auditors would be willing to respond. However, I believed that I addressed these main takeaways from this audit at the start of my discussion today, and I have nothing further to add. Thank you.
Okay, thank you. Let's go up to Art. Art, we'll give you 25 minutes. I don't know if you need them, but we'll turn it over to you. Introduce yourself to everyone, and you can comment on anything you've written or
I will not take 25 minutes, I assure you.
Thank you.
So I am Art Hardinger. I'm a partner in Rennie Public Law Group. I was retained by the Audit Committee in August to answer some discrete questions relative to this audit process. I want to stress that at the outset, we were selected competitively. There were two other law firms who apparently were interviewed. Some of the criteria that had to be observed, I had no relationship. Our firm has no relationship with Sandag. Never done work with Sandag. Never done work with the Audit Committee. Don't know the general counsel. Don't know the executive director, et cetera, et cetera. And it was also impressed upon me that I had no predetermined outcome. There was no direction to come out one way or the other, that I and my team were to act objectively. So with that, the first three questions that were asked were, first one was, number one, is Sandag under a 12-month constraint to void allegedly improper promotions, bonuses, salary increases, et cetera? As I understand it, the auditor led the committee to believe that there was such a constraint. Going into a meeting or before that meeting, the auditor made it clear, actually, there was the government code section that was in play or at issue potentially did not apply. So we were in agreement with the auditor at that point that there was no 12-month limitation. Later, the auditor said, well, actually, there is a potential limitation because of CalPERS rules and regulations. That, as I understand it, the source of the assertion is that CalPERS, with respect to classic members, calculates compensation on a 12-month period. It's called and it's your single highest year of compensation. And so if some compensation was allowed to run beyond 12 years, the agency would be powerless to claw back that money, and it would be forever obligated to continue to pay improperly inflated salaries for the duration of the retiree's lifetime. And so we looked at that and concluded that that's not accurate, that CalPERS retains its discretion if there has been improper compensation reported or any impropriety relative to reporting compensation to make adjustments, and that is contained, in our opinion, at pages 10 through 12. The second question, so that's question one. Question two is kind of imbued in the original draft report of the auditor is our assertions suggesting that Sandag is subject to state civil service laws. State civil service laws are robust and are detailed. And so the question that came, is Sandag under some federal, state, county civil service program? And we've researched that exhaustively and concluded that no, it is not. It is not subject to federal, state, or county civil service law. So the Sandag is an independent special district and has its own authority to adopt its own personnel rules, which we understand it has. And there's an employment handbook that's been in effect for some 10 years or so that lays out things that are sort of merit-based principles, including how recruitments are conducted, how do you appoint people, you keep a recruitment list, rehiring, et cetera. We have, it is true, assumed that this is properly adopted. It's beyond the scope of given our limited time frame to parse through this to see if this is somehow not an appropriately followed document. So we assumed that it was, and again, so the answer to the question number two is, are you subject to some other civil service rules? The answer is very clearly no, and I believe the auditor agrees with that at this point. The question three concerned whether severance payments were invalid because they were based on or because they violated the constitutional principle prohibiting gifts of public funds. The California Constitution does have a very specific prohibition on gifting money. And there's a robust set of case law surrounding that issue. The payments at issue were the severance payments that were identified by the auditor. We've made a number of conclusions there. One is we believe Sandag is subject to the constitutional restriction against gifts of public funds, number one. We looked at the basic law in this area and whether or not a severance payment can be a gift of public funds. And the answer is yes, they can be. And the question is whether, in the context of this case, there were general releases of Sandag. Is there a colorable claim that was in play? Is the amount of money that was paid pursuant to the severance agreement sort of commensurate with the value, if you will, of the colorable claim? So at one point, I believe it was in or around August 29, Sandag's employment counsel, Sandra McDonough, provided us with information concerning each of the severance payments, and we analyzed that information that was provided in terms of what were the individual circumstances surrounding each of the separations, and we concluded that based upon that information provided, which we have no reason to question, there was no violation of the constitutional prohibition on gifting public funds. And each of those cases had standalone individual circumstances. There was counsel involved in evaluating the nature of the potential claim, and based upon our review of the law and the circumstances, there was no gift of public funds with respect to those payments. A fourth question then came more recently, and that is, did the board unlawfully delegate or abdicate its obligation under the law? And as a corollary question, did the executive director unlawfully usurp authority that reposes in the board solely? We've made some assumptions in our report. There's some factual questions that still are out there, but based upon the information that we relied on, we've concluded that the answer is no. There was no unlawful delegation, and the executive director did not unlawfully usurp board authority. I would note that the Public Utilities Commission code gives broad authority to the board to delegate responsibility, and there is also a policy, Board Policy 17, that talks about delegation of authority. From what we know, we conclude there was no improper delegation. And with that, I'll wrap up. Those were the 4 questions that were asked of us. We answered them to the best of our ability. I stand by the opinions, and with that, I will be quiet.
Thank you for giving 17 minutes of our life back, Art. Okay, so now we were going to allow follow-up questions, rebuttal. Any of the 3 of you who's heard anything that the other 2 have said can comment before we move on to questions from the board. So we'll start back with management. Julie, do you have any comments you want to make on anything Art or Mary said? And if so, how much time do you need?
I think I only need 5 minutes. And
okay, we'll give you 5.
Let me go ahead and get started. So we want to be really clear here that just because management disagrees with the audits, it doesn't mean that management has interfered in anything improperly with regard to this audit. Reasonable minds can disagree, and there's no impropriety associated with that. Management has disagreed, but we did not interfere. And we would also like to note that the board of directors did not vote on this audit or demand that it be done in August. That was information volunteered by OPA, but never voted on. We also don't understand what the independent performance auditor means by manipulate. We completely reject any connotation that anything other than protecting confidential matters is going on here. We did remove one of the attachments to the draft audit because it was provided elsewhere in the package. So the information is still there for everyone to see. Names and dates were deleted only when they could be used to identify an individual employee. I also want to note that it was stated that the draft should not have been issued because it should have stayed under OPA's control. However, it was released on September 4th, and the decision of what to issue and what not to issue was taken out of everyone's hands at that point, including management and the audit committee. We also want to share that the audit committee, who are the decision makers here, do have the unredacted documents. And with that, I'd like to turn it back over to you, Chair.
Okay, Mary, do you have further comments, and how much time do you need?
Just probably 5 minutes as well.
Okay, go ahead, you got 5 minutes.
So just to clarify some of the important things that should be pointed out with Art's comments is we generally did agree with the initial conclusion that Art came to around the first comment, CalPERS. That was really not an assertion by us. By the way, our reports are not asserted. They're supported and documented evidence. There's no assertions or assumptions in audit reports. I will say that the CalPERS matter was a recommendation, not a finding. So it wasn't necessary because really management can agree or disagree, and they can act or not act. We have no problem with that. That happens often. But it was really a recommendation, and it had nothing to do with the audit. I will also agree that the 12-month other reference never stated by us. It was never included in any of our documents or reports, and was really came out of, I have no idea where it came from. The state civil service reference was actually referenced as a best practice in the draft report. And the only reason we referenced it as a best practice was because their procedures around hiring mimicked the merit system and fair hiring practices. And so we included that as a best practice to follow. What our issue really was is that they were not following their own policy. So to clarify that. Also, the employee handbook, where many of Art's assumptions that everything that was done okay, was the assumption that the employee handbook was a document that is the board policy. It has been adopted and reviewed by the board. And I will again confirm that it has not been. So therefore, the assumptions or the assertions made by him would at that point become moot because there was no adopted document for the employee's handbook by the board. Lastly, our issue with severance pay goes back to a few things. There was no policy on severance pay. There was no involvement by the governing board on a claim against a government agency. The board should be involved on claim. It was in fact a claim, which we had no evidence or support that it was, or even a colorable claim for that matter. And had a policy been adopted by the board that delegated that authority, we wouldn't have had any problem with this point. However, that was not the case. The delegated authority and the board was excluded from these decisions. The only signature on these severance agreement was the executive director, meaning a claim against Sandag, a government agency, had no involvement by either the board or the general counsel for Sandag, and was simply signed by one individual, which shows and further supports our claim of weaknesses and lack of controls within the organization. That's all I have to add.
Julie, only you a minute and a half of rebuttal time. She's asked for a brief moment to ask another rebuttal question. Go ahead. But you're still under the total 5-minute rule, Julie. Go ahead.
Sure. Okay, so I think that one of the things that's been brought up again is the issue of the latest opinion from the Renee Group and how it relies on several bases for determining that the delegation is appropriate. Only one of those being whether the employee handbook has been approved in substance by the board. In actuality, though, there's 3 other bases for the position of management that the executive director's authority is appropriate. One of those is that SB 1703 delegated that administrative authority directly from the legislature. The second is Board Policy 17, which the board does in fact approve. Third would be the board's control of the budget. And, you know, if there's any concern, the employee handbook can be brought to the board, but we believe that just because one of the assumptions that Renee relied on is the situation we have here, it doesn't mean that the other 3 bases go out the window. And that's all.
Thank you. Now, Art, you have 5 minutes if you want to answer anything, or you don't have to, but go ahead.
I will be less than 5 minutes. 2 things. I would say that, number one, having practiced labor and employment law for over 30 years, I don't know anybody who would suggest that the state civil service system constitutes a best practice. I would just say that's just my opinion for what it's worth. But 2, the last thing would be, there seems to be an implication that there has to be some sort of formal claim made or asserted in order to avoid an unconstitutional delegation, an unconstitutional gift of public funds. And I see Mary shaking her head, so maybe she knows where I'm going with this. We conclude that you don't need a colorable, you don't need a formal claim, you don't need a threat. And in this case, again, based upon the information that was provided to us, we felt comfortable that each individual circumstance raised a basis for a severance that would release Sandag. And that's all I have.
So Bill, may I?
Okay, well, thank you. Who said that, Mary?
Mary, quickly.
Mary, you have, I think I have a minute and a half left of your 5-minute rebuttal, so go ahead and use it.
So again, when you have a policy that mimics the state service, using that as the best practice to have fair and competitive hiring practices is completely appropriate. It happens in an audit report often. Also, I agree with you that a colorable claim or a potential claim does not have to be an actual claim. However, there should be some sort of documentation supporting that there was a potential threat of claim or colorable claim, which they could not provide us until after the fact, which then a document was created. So we requested evidence of any kind for a colorable or evidence of a threat of claim, and that could not be provided. Additionally, the other document that they rely on, the administrative rules and regulation, clearly stipulates the restrictions that basically hold back or puts restrictions on what can be delegated to the executive director, as well as Senate Bill 1703. If you'll note in there, very distinct language that states at the direction of the board and subject to the board. And our whole point goes back to there needed to be policies, or the board needed to be informed, and most certainly the general counsel of the organization should have been informed when they're signing something that creates possible litigation and liability to an organization such as a government that handles $1.5 billion of public money. That's all I have to add. Thank you.
Thank you. Now we're going to go to the second phase of the meeting. Our 3 speakers had their opportunity. Now it's under the control of the audit committee. And we'll have 2 pieces of this. One, the audit committee can ask any member of the audit committee can ask any of the speakers a question. But, and then after that, we're going to go into the motion and recommendation phase. So, Stuart, you really wanted to talk at the beginning, and I asked you to hold off. So you want to go now. If you want to, you can say what you want, or you can frame it in a question to management, but go ahead. Let's just, to be respectful to everybody, give it, how much time do you think you need, Stuart? Just like 5 minutes, 10 minutes?
Yeah, I don't know, maybe it's 5 minutes. I actually have, I think,
Okay.
maybe 2 or 3 questions for Julie, I think 1 for Mary and a couple for Art, so I don't know how you want to.
Okay, let's go through all your questions. Go ahead, Stuart. And then Paul, I'll put you on deck, then Bob, then Bill, okay? So go ahead.
Can I ask Stuart, pull the microphone closer, Stuart. You kind of go in and out. So if the microphone were closer, it would be easier to hear.
Okay, I will try to also speak louder. Thank you. So first, I guess for Julie, I'm wondering if she or anyone else at Sandag consulted with the OIPA regarding the proposed redactions ahead of time, and if not, why not? Because I firmly believe no management or audit committee should be in the business of in any way unilaterally altering an independent auditor's report. And particularly given the history of the 2016 scandal, I also firmly believe it's in Sandag's best interests to err on the side of being painfully fully transparent. So that would be my first question. I think Mary, a second question for Julie, I think Mary mentioned that she actually did not receive the management revised report. I don't know if Julie or somebody else can speak to the question as to why Mary would not have been sent management's revised report that is addressed to her. Should I proceed to the questions to Art, or do you want to deal with those, Bill? Hello?
Wait, I'm sorry, Stuart. Let's get, as you ask the questions, let's get the answer. Am I correct that those first 2 were to Julie?
Yes.
Okay, Julie, do you want to answer?
So the first question regarding any consultation regarding the redactions, the way we address that is in our response to the draft audit. We pointed out that identifying information regarding employees or things that could lead to claims against the agency should be removed. However, when the final audit came out, it still contained the information. The only thing that got removed were employee numbers, but that didn't take away the problem of still having too much identifying information. So we did attempt to ask that that information not be included in the final draft. However, we did not get the response we were hoping for from OIPA. We also were following the California Public Records Act when we made those decisions to redact, and or following the standards that are set by the Brown Act for closed session materials, and getting advice from your attorney when there's potential litigation based on what was in those documents. So that's the answer to question 1. Question 2 regarding the revised response from management, that was given to the chair of the audit committee. And I do not know, honestly, whether the chair was able to pass that along, but we do know that whether he did or not, the bottom line is that OIPA has a copy of the documents.
Gotcha. Okay, that's just a curiosity because it was addressed to Mary, so I would have thought someone would have sent it to her. But if I could just quickly follow up your comments on the redaction. You know, Julie, I've known you for a long time. I respect you. When I look at page 396 of the package, the redaction of the what seemed to me be fairly innocuously worded, during the reporting stage of this audit, staff within the OIPA were subjected to instances of what appeared to be retaliatory and hostile tactics. I just don't see how that in any way is consistent with the definition you just gave of what needs to be redacted information. So maybe at another point somebody can explain that to me. But
And I can answer that question if you'd like. Whenever we have a claim of retaliation or harassment or discrimination by an employee of the agency, no matter what level they're at, the first step that is taken is an independent investigator is hired to investigate. Actually, sometimes we don't need an independent investigator depending upon what's going on, but in this case, clearly an independent investigator was called for. And so an independent investigator has been hired to investigate the claims and counterclaims that you're referring to. However, once you have a claim situation, an investigation underway, again, under the California Public Records Act, that information should not be released to the public. So that is why that was redacted, because it was an allegation. Management acted upon immediately, but both the allegation and management's response to the allegation within its response were redacted from public view.
Okay, then again, maybe we just need to follow up. It just strikes me that that's information that might be, the public might consider to be material for them to know about. But I can move on to, I just have a couple of questions for Art, Bill, and please, advise.
Go ahead.
It's a time limit.
Go ahead. Go to Art. Go ahead. Go to your question for Art.
Yeah, so the first question relating to the materials in the September 10th memo, you mentioned numerous times that the opinion relies on assuming that the employee handbook was properly approved by the board. You said that a number of times. I think you mentioned that even today. Were you presented with any evidence that the employee handbook was in fact approved by the board? And if you weren't, did you ask for any evidence?
Stuart and Art, this is Paul. Mr. Chair, would it be okay for me to respond to that one?
Stuart, I know Paul's answer. It would be the answer. Do you want to, I can make him wait, or you can hear it directly from Paul. It's up to you, Stuart.
I'm happy to get the answer.
Okay, go ahead. Stuart, then you're allowing Paul to jump in here? Go ahead, Paul.
If Art wants to agree with whatever Paul says, sure.
Or disagree. He's a pretty independent guy. I'm confident. The answer is that I went back and went through Mary's, the OPA's report, and one of this is in finding one, there's some confusion, or there's a conflating of two issues in my mind. One was, were these documents properly adopted with the corporate formalities? And then second, even if they were, was a delegation of this authority per se illegal, such that, if you had dripping hot red wax with a ribbon attached and everything, all kinds of formalities, you couldn't do it anyway. And that one was also involved in finding one. And so what I asked Bill, I wrote that question, the question for, I was the one who authored it. And I asked our chairman, in order for me to understand the audit report, it's very important to me to know if they could have done it. And so Bill said, all right, you're authorized to do that. So the question, and the committee, the five of us had appointed appointed Bill and me to pursue this, to get the legal answers. So we were the right people to do it. And so I asked Art and his team, make the assumption, and this is theoretical, but you'll see that the text in his memo is exactly what I sent him, or very close to it if he changed my punctuation or something. But make the assumption that every document that's been questioned as to corporate formality adoption has been properly adopted. Would this have been legal at all, or is it illegal? Because if it can't be done, we don't need to be worried about whether or not documents were properly adopted. If it's not legal, you can't go.
I appreciate that. But on the other hand, if it's theoretically, allowable, but it was never approved, that's a problem itself. And I think that might be the fact that the auditor's finding speaks to.
Well,
so that's why
I read it opposite. I read it that there was not proper adoption, and in addition, they couldn't have done it anyway. So my whole goal is to separate that into two questions and to get a clean answer of could they have done it. Then you can deal with the question of were the adoptions proper, or why are we wasting our time on the adoptions if it's illegal per se? So that was the goal.
Makes perfect
Stuart,
sense.
can I simplify it with your permission? there's a principle operation law that at times you assume a fact in order to get to the legal issue. There are whole pleadings, they're called judgment on the pleadings, where the judge says, I'm not arguing whether the facts are true. Let's just assume they're so we can understand the law. This is sort of the function. And I think Art said it in several ways, meaning whether the fact occurred is not really what the question was, it was the legal thing. So I think it's a bit of a red herring, but don't worry about it because there are other ways of rectifying. But I understand why someone who's not a lawyer would look at that and assume the worst, but it was that, I should have written the question better, so.
I think.
Can I help out a little bit?
Nope, absolutely not, it's not your turn.
Let me just finish if I could. I think this is the difference perhaps between, a legal situation and an audit. An audit is based on facts. So, I appreciate the legal question, I truly do, it's relevant. But having answered the legal question, we're still remained with the factual question, which is what an audit is about. And if an audit uncovers, the fact is it's what was the fact? And Mary's saying her audit uncovered the fact that it was not approved. And that is, maybe it's a...
Stuart, it's not intended to be a contradiction to what Mary's saying. Sorry, my screen keeps popping up with weird stuff. Because think about this, Stuart. Every document that Mary has put out goes to the board. Okay, the board's going to get Art's work too. They're side by side. So when they get to the board, Mary can have a factual dispute with the board as to whether it was adopted or not in the legal meaning. It's okay. And I understand why someone might complain about it, and it probably should have been better written. But remember, we're the way station here on the way to the board. We're not even the final arbiter. So what documents go forward is really, and the meaning of those documents is up to the board, okay? So you can, that's the quick answer, but you can go on as long as you want. But I got to give the other guys a shot too. Keep going.
Okay, so I just have a final question, and I'll take that as Mary is claiming that the employee handbook was not approved by the board, and I suppose management is not presenting evidence to counter her claim. Okay, so then the final question I have for Art is, it speaks to how he got comfortable with the notion that there was a colorable claim. And it sounded to me as if you came to the conclusion that there was a colorable claim because Sandag's counsel told you that there was, and that you had no reason to question that. So my question would be, just taking the assumption the other way around, if there was no colorable claim, would the payments then have been improper?
Okay, Art, you want to answer that?
Yeah, nobody likes to hear this answer, but the answer is maybe. These are fact-specific kind of inquiries. I received a comprehensive memo from Ms. McDonough that was detailed. And so, again, they're fact-based, and there's just no way for me to definitively say yes or no. I mean, in California, every time you separate somebody, there's risk. It's just the way it is.
Okay. Stuart, do you have any more questions?
No, I appreciate the indulgence, Bill. Thanks for the time.
Okay. Paul, you're up, and Bob, you're on deck. Go ahead, Paul.
Oh, okay, and I've got a question just for Mary, but before we go forward, I will say, Stuart, I agree with you and with Mary that, as far as I'm aware, there is no evidence that the board ever adopted the employee handbook. That really isn't the issue. The issue was to, in that thing, just assume everything was adopted, or is this a legal delegation? That was the goal. But I agree, and I think Mary agrees, and I think management agrees. There's no evidence that I'm aware of that the board adopted the employee handbook. So we're together. My one question to Mary, you went pretty quick.
Paul, certainly not explicitly adopt, definitely.
Well, yeah, there is an argument that the board did adopt it by incorporating it by reference into a different document, which they did apparently vote on. So there's at least an inference that the board there would be an argument that the board did adopt it by reference because they referred to it and said the employee handbook shall apply, although I can't find a resolution that the board says we hereby adopt the employee handbook. So it's that kind of inferential. My one question for Mary, because you went kind of fast on this, and it was important to me, and I couldn't get it in your we were time compressed. You said Julie Wiley interfered in some way, and you went too fast, Mary. Would you go back and just summarize how Julie Wiley interfered? Because I missed that point.
Actually, that wasn't what I stated.
Okay. Thank you.
Well, no, I will restate what was stated. So first, Paul, your understanding of finding one was not quite nailed on, I would like to say. But as regarding Julie Wiley, all I pointed out was as Julie Wiley, who is the director of the Contracts and Grants Department, responded on behalf of management. And then I proceeded to discuss that it was a salaries and benefit compensation audit, not related to contracts and grants. And I was just making that point. There was nothing that I disagreed with her other than some of her statements on behalf of management.
Okay, I thank you very much. I did get confused apparently.
Okay, Paul, do you have any other questions for Art or Julie or Mary?
No,
okay.
Thank you.
Then let's go to Bob. Your turn, Bob. Are you muted, Bob? There.
Everybody hear me? Do this here.
Yes.
Okay. All right. So I have a few questions. I'm going to start with one for Art. And Stuart kind of asked this question. It's going to be a similar question, but I want to make sure I'm kind of clear on what you said, what I understood from the prior meetings. And it goes back to the idea of gifts of funds and the severance payments. And you had mentioned that make sure I'm getting this right, that there doesn't have to be a need for a claim or a colorable claim to not have a gift of funds or have these. Kind of explain that to me again, if you wouldn't mind.
Sure. So the first issue, which I think one way to characterize it, and I think that the auditor agrees with me, is that you don't need to, for example, many times when you sue an agency, you have to file a claim, a tort claim. So that's not necessary. Sometimes you can have somebody, a lawyer could write a demand letter and say, you know, I was wronged in this way or that, and that would be another sort of a threat of litigation. And we're saying those things are not necessary in order to avoid the restriction on a gift of public funds. There does need to be some risk assessment. There needs to be, and I agree with the auditor that a best practice in this area would be to have some form of documentation supporting the basis for the separation somewhere. And it's my understanding that does exist. I was relying on this McDonough's memo, and that indicates to me that there was a thorough risk assessment with respect to each separation, which I think is sufficient to avoid the constitutional problem.
Okay. So this is going to be a follow-up question, but it's really directed to Julie pertaining to this. I think Mary had made the statement and that during the audit process, the field work, if you will, when they had asked what documentation was there to justify the potential for a claim, they didn't receive any. They didn't receive that until it was there. Why not? Why wasn't there any documentation when the auditors originally asked for this?
So I want to first, since it's been brought up, just to let you know. So I am legal counsel for the agency and have been for 20 years now. I wrote a lot of Senate Bill 1703 and almost all the board policies in their first round. Was the legal advisor on employment law for the agency for 17 years. So I was asked as a special assignment to work on this project to assist management due to my history with the agency. So I wanted to provide a little explanation on that. As to the question, though, that it has been posed by Bob, I think that I was not involved in the process originally of the audit and what was asked for and how it was responded to. My understanding is that many document requests were made by OPA and that staff tried its best to respond to all of them as quickly as possible, but there were very strict time constraints on responses. And with COVID, it made it difficult to search for records, especially old ones, as some of them are not electronic files. So I'm not sure if that totally answers your question, but hopefully that gives a little color.
Chair, if you can kind of, I have one more question that I wanted to ask Mary.
Go ahead, ask as many as you want, Bob. I know you have a 2:30, so I'm factoring that in.
Okay, thank you very much. Mary,
a little color.
Question I have here, and this actually goes back to your first finding, which relates to whether or not the board or whether or not the executive director had the authority to do this. And I don't know if you can do this in a summarized fashion, but I want to make sure I'm clear as to kind of what the elements of that finding were, your criteria, the condition that you found, and what documents had been given to you, and kind of what the gist of your finding is, because I've kind of heard differing viewpoints. And so I want to get some clarity from you. Does that make sense?
In a quickest way as I can explain it, and I may ask Michelle, who was the lead on this, to jump in if I'm missing anything. But basically, when we inquired about this, we were first being told straight off the board that it was considered a contract that the executive director has the authority, as long as it's under 300,000 within the budget, to make these decisions and write these contracts. We said that, well, this is a claim, it's not a contract. Contracts are for services provided, claims are litigation, potential litigation and risk against a government agency. We were then later told it was for a claim. They threatened to claim. We asked for evidence provided to us. There was in fact evidence of a threat of claim or a claim. We were provided a document that clearly was titled severance. We looked at the fact that the individual was an at-will employee with or without cause could be terminated. The individual voluntarily resigned. And we looked at, was there a policy on severance pay that allowed for severance pay to even be made? And we found none of that. They later then started down this road claiming a colorable or potential claim. So we asked evidence for that, and was told by more than one member, including the general counsel, the director of HR, and Hassan in his own initial original management's letter, that there was no evidence of a claim. Then later, after the report was finalized, Sandy McDowell, if I'm saying her name wrong, I apologize, after the fact, wrote a long, extended memo in which Art relied upon that basically was making assertions and assumptions that justified this colorable claim. That document, again, wasn't provided to us and was kind of made up after the fact, along with the other documents that we just didn't consider because it was conflicting with the evidence that we had already obtained, including interviews that we had obtained with high-level staff that should have been involved. And so our main issue around one was that There was no documentation to support the claim. There was no policy on the ability to pay a severance pay. And the board or the general counsel wasn't involved in the settlement. It simply had Hassan's signature and nothing else. So those were our main issues.
Okay, all right. I think I'm going to hold off on the other questions for right now.
Okay, so let me,
I'm good.
because we have a half hour left with your valuable time, Pam, let me move to the end game here. We on the audit committee are a policy advisory committee of the board. We have a duty to advise the board on this issue. This is independent of Mary's duty, and Mary is going to be able to put her full case on in front of the board, and management's going to be able to put on their full case, and if Art will tolerate us, he can speak to the board too. But independent of those three, we are expected to make a recommendation to the board. So with that in mind, I asked Paul to work with Sandy, our inside counsel, to come up with a draft recommendation on each finding, and I'd like to go through one by one. There are Paul's draft, which he gave me in writing, which I just cleaned up, but I left the content as is, has a number of proposed recommendations. So for Bill and Stuart and Bob and myself, you don't have to take it. You could say, that's the dumbest thing I've ever heard, Paul, we're not doing it. Or you could say, it's pretty good. Or you can say, we'll do it if you change these 3 words. And I'd like to, just for operational efficiency, vote on each section. Because we have like 14 sections to go through. If that's okay, we'd like to start. And Bob, I'd like to do this while you're here because we value your input. Is that acceptable to you, Stuart, and Bob and Bill?
Chair, I just wanted to interrupt and say we do need to acknowledge public comments before a motion is made.
How many public comments do we have?
At the moment, I see none. We may want to give people a second to raise their hands, though, if they do want to speak. There's a lot of these.
While on that, Bill, if you alluded to this being in the form of a document, can you forward the document so we can actually read it?
To simplify it, it's document because it's my notes. I've asked Sandy to put each section up on the screen, so screenshot it. All right, that's the one way, Bob, we can guarantee everyone will have the same text. Okay.
That was Stuart.
Okay, let me know if public comment comes in. If not, we'll roll. So
I don't see any hands raised.
All right, so Sandy, can you put up the Paul's motion? We're going to treat this as Paul's motion. Okay?
Can I go ahead and formally make it, Mr. Chair? I did provide to you, and you did make a couple of comments on wording with which I agree, and so you now have it, and I move that one by one or en masse or however you procedurally handle it, that our committee adopt these resolutions that I'm proposing. I will comment that they, for the most, I think the vast majority of them align with management and OPA, although there are some that disagree, and that's fine. So
okay, so I'll second that for discussion. So let's go, as to finding 1, I'm going to put some common terms on there. They're not the official terms, but the way I track them. This is the handbook question. Yes, so can you put up Paul's, the subset of Paul's motion as to finding 1? Okay. Why don't we just set a standard rule that Sandy will read it into the record, even though it's right there. And then Paul, you can comment on it, and then we'll let anybody else comment on it back and forth, and then we'll have a vote on it. So go ahead, read it into the record, Sandy.
Okay, and these track the findings in the final audit report. So as to finding Roman numeral 1. Number 1, the audit committee finds that the board appropriately delegated authority to the executive director through the executive director's contract, Sandag's employee handbook, and in accord with the governing sections of the Public Utilities Code. Number 2, the audit committee finds that the board implemented bylaws and replaced the administrative rules and regulations which are no longer in effect. Number 3, the audit committee finds that the board implicitly ratified Sandag's employee handbook, and the board is stopped from retroactively changing prior employee contracts. Number 4, the audit committee recommends management present the current employee handbook to the board for retroactive review and approval or ratification as applicable. Number 5, the audit committee recommends that every Sandag employee acknowledge receipt of the handbook and bylaws upon hire and acknowledge its continuing applicability on an annual basis thereafter.
Thank you. Okay, Paul, do you want to explain any of that before the rest of the board members get to ask you questions?
Yeah, I'll address number 3 and 5. 5 is first. You know, you see errors right after you hit the send button. In number 5, the word "it" should be there because there are two things, the handbook and the bylaws. So it's not.
Okay, for the record, Sandy, do you have, when we're fixing things or the board makes recommendation, can you do a live fix? Okay, so if it's a typo, okay, there you go. All right.
All right, and then number 3, somebody's going to ask, what's that about? And the answer is, I can talk about employee matters here, I think. It's, Bill, is that okay in the public session?
Be careful with names, titles, but go ahead.
All right, so there is a particular high-level employee who has a contract from the board, signed by the board chair, and then a year later signed by the next board chair, a modest amendment of it, which says basically that the employee handbook will govern the terms of that person's employment, except to the extent the written contract agreement overrides the employee handbook. And that's where I found the implicit adoption by incorporation of the employee handbook. I mean, okay, so that's the end of my thing. I felt that this is a good way to deal with finding one in terms of our recommendation to the Sandag Board of Directors.
So to clarify, you're saying this high-level employee has a contract that says the employee handbook is the governing document, and the contract of this high-level employee was ratified by the board, and you're saying that's a sign that the board did understand the binding significance of the employee handbook. Is that a summary of what you just said?
Yeah, that's a bit of an overstatement, but yes, the board likely authorized somebody to sign the employee's, high-level employee's employment contract, and section 2.4 of said contract appears arguably to incorporate by reference the employee handbook. That's
okay. So now let's go to questions. We'll go, just because it's the order I remember. Stu, go ask, you can ask yours first. We'll go Stu, Bob, Bill Wells.
Well, I guess this is maybe more of a comment than a question.
Yeah, when I say question, I mean comment or suggested change. I'm sorry, just your turn to talk.
Okay, thank you. So it strikes me that a more productive approach would be perhaps to go through Mary's recommendations and comment on those, because otherwise it feels a little bit like we're making it up as we go along. And, you know, process-wise, again, I respectfully just have to object to the way that this is being handled. This clearly is not something that's just been, it almost feels conspiratorial in terms of that this has been in process. People have been working on this. To just throw it at us right now, I guess I just object to the process, and respectively would be forced to vote no on everything in the way this.
Okay, fair enough. Bob.
Can everybody hear me?
Yes.
Can you all hear me?
Yes.
I'm somewhat leaning in Stuart's direction, and again, it simply seems to me, and I appreciate the work that's been put into this, but Mary has made recommendations. Management has actually responded to most of those recommendations, agree, disagree. I'm not sure, as a committee member, I'm comfortable in agreeing with this. So I'm just going to leave it there.
Okay, if you have a right to do that. If basically Stuart and Bob, you're saying based on the process you want to vote no on the items, that's your right. And if you don't want to, change it, that's fine. Bill, do you have any questions?
No, I kind of want to hear what all of you have to say. You've got so much more experience than I have in this. The only My only question is just, where does this all go, and practically, what's the best?
Well, here's what I'm trying to get to, Bill, is you and I have these dual roles of being here and on the board, but the board expects their policy advisory committee to review all the documents, including Mary's documents, including the management's documents, including Art's documents, and sort it out for them. That's what this is doing. Stuart and Bob, we're kind of like a typical audit committee, but we're kind of not. We have a duty to make recommendations to the board, and that's what this is designed to do. So, basically, Bill, when we send this up to the board, we will be telling the board, here's the best, then it's in the board's hand. And you know the board can dismiss every single word we say, but we have to send them something. You know, you may even dismiss your own words when it gets to the board, but the point is we got to send something to the board.
The extent that our responsibility relates to this audit report, I'm totally comfortable going line by line with Mary's recommendations and speaking to those. But just to make up something on our own, despite the diligence that went into it, I don't feel comfortable with that.
Okay, that's a no vote, no problem. So if we don't hear any, let's have a vote on this subsection, okay? We've got a motion, we got an action, we got a motion, we got a second. I guess, Francesca, we have to call the roll, right, on this section.
Yes,
Bill,
I believe so.
please,
Yes.
can you just summarize it again for me?
Summarize what
the motion is?
It's on the screen. Can you see, I'm sorry, Bill, can you see the screen?
No, I'm sorry, I can't.
Okay, that's a major point. Can I have Sandy read the 5 sections for you? Oh, and you can hear it. Everybody else is looking at a screen, Bill. That's why you're limited. Okay, Sandy read it all. Will you read it again for Bill?
Sure. As to finding Roman numeral 1, the audit committee finds that the board appropriately delegated authority to the executive director through the executive director's contract, Sandag's employee handbook, and in accord with the governing sections of the Public Utilities Code. Number 2, the audit committee finds that the board implemented bylaws and replaced the administrative rules and regulations which are no longer in effect. Number 3, the audit committee finds that the board implicitly ratified Sandag's employee handbook and the board is stopped from retroactively changing prior employee contracts. Number 4, the audit committee recommends management present the current employee handbook to the board for retroactive review and approval or ratification as applicable. Number 5, the audit committee recommends that every Sandag employee acknowledge receipt of the handbook and bylaws upon hire and acknowledge their continuing applicability on an annual basis thereafter.
Okay. You have that, Bill?
I do. Thanks for doing that.
Okay. All right, so let's do the roll call vote. You know, we've got 14 of these to go through, so I'm trying to move through briskly. Go ahead, Francesca. Yes. Aye.
Sorry about that. From the City of La Mesa, Chair Baber.
Aye.
City of El Cajon, Mayor Wells.
Aye.
From Public Member Paul Dostart.
Yes.
Mr. Stuart Halpern.
No.
And Robert Monson.
No.
Okay, the motion passes 3-2. Let's go on to finding 2. This is the severance agreement. And there's actually, when I look at your notes, Paul, there's actually 2 sections that regard the severance agreement. So let's go with the one that's as to finding 2. And go ahead, Mary, Sandy, can you read in the record so Bill can hear you?
And can you put it on the screen though, too?
And put it on the screen, too.
As to finding Roman numeral 2, number 1, the audit committee finds, based on RPLGs, and that's the Rennie Public Law Group's independent analysis, and upon review of the background analysis prepared by Sandag's outside employment law counsel, that the severance payments were not an improper gift of public funds. Number 2, the audit committee recommends that as a best practice, past and future severance payments be supported by adequate documentation.
Okay, so Paul or Sandy, do you want to comment on either one of those? I mean, these, it's sort of self-explanatory,
I
but
don't
go
think
ahead.
it needs a comment. I think it's self-evident.
Okay. Okay, Stuart, any comment on this, or are just going to have a running no on the process, which is fine?
Yeah, again, apologies, Bill, but that's pretty much the way I feel about it.
Okay, Bob, do you have a running no on the process, or do you want to comment on this particular one?
I guess I would say that my interpretation of Art's answer to question 1 is different than the way it's stated.
In what way?
I believe that when I asked Art if he was just relying on Sandag Council told him there was a colorable claim and that there was not a colorable claim, would the payments have been improper? He said maybe. So it just seems to me that we just really don't know the answer.
Art, can I ask you a discrete question if you're still there?
I'm here.
Based on the information provided you, confidential by Sandy McDonough, regarding the nature of the claim, did you find there was a colorable claim?
Yes, I did.
So based on the fact that you found there was a colorable claim, in your opinion, was there an improper gift of public funds?
My opinion is, based upon the facts provided, there is not.
Okay. All right. That helps, Stuart? I mean, you may not agree. I'm just trying to clarify it.
Yeah, I think that was a very artful way of asking the question. Thanks.
Okay. All right. Bob, are you a running no, or do you want to consider this one?
Want to consider this one.
Okay, go ahead.
So I'm looking at. Okay, I'm ready to answer it. I don't need to ask any questions.
Then let's do the roll call.
Bill, can I ask?
Is that Bill?
I didn't hear.
Go ahead.
I didn't hear Paul Dosart's opinion of this.
Paul didn't say anything. He said the words speak for themselves. Do you want to say anything to elaborate for Bill, Paul?
Assuming that I'm not very bright when it comes to audit stuff. So
yeah, and keep in mind, Paul, Bill can't read the words, so you have to be clear in your explanation. Okay, Paul.
Okay, Bill, I did read the confidential. Maybe it was, I don't remember if it was 5 to 8 pages, single space, prepared by Sandy after the fact. It appeared to me to have been prepared in August 2020. Walked through the basis on an employee by former employee basis, included a copy of a demand letter from an attorney and so on. I have been an employer. I've owned a business in San Diego County for over 35 years, and I've had employee turnover, both voluntary and involuntary, and understand these claims. And Art made the comment, if you're an employer in California, you're in a high-risk profession or business. I mean, he didn't say quite that, but that's what he meant. And as I read through the claims, our colorable claims, they were logical ones that would be presented or presentable and do get presented. I've testified in court on these things and so on. I just felt it looked very straightforward and normal, and I do think that going forward they ought to do a better job documenting these things, but I didn't have any concern that there was a gift of public funds. That's the basis of it.
So did all the members of the committee have access to those documents and I just missed it, or was Paul the only one that did?
I don't know the answer.
Well, this subject came up in closed session, Stuart.
I know the subject did, but I'm talking about the documents. Were they provided to the committee or?
No. Well, Sandy, do you know? Because these were.
I provided it to the outside counsel.
Yeah, this is the highest level of confidentiality. So no, I don't believe so. So if you don't believe because you didn't read it, it wasn't true, no problem, just vote no.
So if we vote yes, then we're affirming Mary's assertion. If we vote no.
If you vote yes, you are saying there was no You're affirming Art's assertion, is a better way of saying that.
Yeah, staff's assertion.
Yeah, you're affirming the opinion of the outside counsel.
And then at that point, does
number one.
it not go to the board, or does it go to the
Yep.
board?
It goes to the board. All we're doing, Bill, is saying, look, the audit committee reviewed these, here's our opinion. You know the board can completely ignore us, and probably will.
So either way, it goes to the board.
Right, and you get to vote on that at the board again, Bill, so.
Yeah, okay.
Okay.
And
Can
I'm
I
sorry,
call
to
the
be
question?
clear,
Hold on, Sandy, do you have a question?
I also yes, it's on. I also copied Mary Kay on the memo, as well as management, general counsel.
Okay.
So the auditor does have a copy of it.
Okay,
confidentially.
so
I do
somebody
not
called the
have a copy.
question.
Sorry, I
Let's,
need to respond to that. I do not have
Nope.
a copy of these recommendations. They were not provided to me, and these are not
Okay,
the auditor's
Mary, it's not your
recommendations.
turn. It's not your turn, come on, it's not your turn. Okay, we're going to have we called the question, let's have the roll call vote.
Thank you, Chair. From the City of La Mesa, Chair Baber.
Aye.
City of El Cajon, Mayor Wells.
No.
Public Member Paul Dustart.
Yes.
Public Member Stuart Halpern.
No.
And Public Member Robert Monson.
No.
Okay, so that motion fails on a 2-3 vote. Does anyone have a substitute motion related to the severance agreements? If not, we'll just leave it blank and move on. Okay?
I can tell you what I feel is I really want this to go to the whole board.
It is, but we're making recommendations to the board, Bill.
I get that. I just that's where my head's at. Okay.
So there's no motion related to Mary's finding 2 unless someone makes a substitute motion. If not, we will move on. Okay, let's go to finding 3. This is what I call the payments in the Terry Sinat letter. So why don't you put it up on the screen, and why don't you read it into the record so Bill can hear it, okay?
Yes. As to finding Roman numeral 3, number 1, the audit committee finds that payments made to the former chief deputy executive director were a proper use of public funds, and there was no intention to conceal those payments from the board. Number 2, the audit committee does not recommend adopting the OIPA's recommendation to rescind approval authority. Number 3, the audit committee recommends that Sandag Management develop a policy for board approval to address these situations in the future.
Okay, Paul, your turn to explain anything.
I think it's clear. It seems clear to me, and the answer is that they ought to step it up in the future so that we don't have to go through this drill. But I have gone through all of those documents, and I am satisfied that it was acceptable, just not well documented contemporaneously, and therefore for the audit committee to recommend to the board of directors, having gone through that drill, this is what I recommend we do, just adopt this set of 3 resolutions as part of finding 3.
Okay, so Bill, if I were going to summarize it, number 1, the finding 3.1 says that situation with the former executive director that Terry Sinat signed off on and wrote the letter was a proper use of public funds. That's what yes, and there was no intention to conceal those payments from the board. That's what a yes vote means. The second subpart is the audit committee does not recommend adopting the OPI's recommendation to rescind approval authority regarding that particular set of payments. And then the third one was a recommendation to Sandag Management to develop a policy for board approval to address this type of situation in the future. Okay? So any questions from you, Bob? I'm just going to, Stuart, I got your rolling no, it's cool.
So I'm kind of looking back on the final audit report, and it seems like in this particular case, the recommendations really are answering Mary's recommendations, whether we agree, disagree. Maybe, Paul, you can kind of help me understand that. For instance, number one, we disagree with her recommendation, and we find that it was a proper use of public funds. That's kind of what it seems to me is the gist here. Am I catching on, Paul?
I think that's correct, Bob. That,
okay.
In the end, I think our chair just said the executive director, but I think it's actually the chief deputy.
Okay.
And that in terms of the 21-member board of directors sorting through all the documents, we're an advisory committee. I have done that. My conclusion is that it was a proper use of public funds, and that would be the recommendation I would like to see come from the audit.
Okay. All right.
All right. Bill Wells, do you have any questions on finding 3?
So
this is the Terry Sonat letter.
Right. So voting yes is agree with staff that it was a proper use of public funds.
Yes.
Okay.
Okay.
Call the question.
You don't have to keep doing that.
All right.
Paul. When I flushed out everything, we'll do it. Go ahead. Believe me. There's only 5 of us. Come on. Go ahead, Francesca.
Thank you. City of La Mesa, Chair Baber.
Aye.
City of El Cajon, Mayor Wells.
No.
Public Member Paul Dustart.
Yes.
I'm kind of busy
Public
here.
Member Stuart Halpern.
What?
No.
We haven't done it.
And Public Member Robert Monson.
Yes.
Okay, I lost track here. I got distracted. Was that a 3-2 yes?
Correct. 3-2 yes.
Okay. Okay, let's go to finding 4. Okay, this is the allegation. There was a breach of fiduciary duty, is the way I wrote my notes. Sandy, do you want to read into the record and put up on the screen the proposal? The proposed motion, the motion, basically. It is a proposed motion.
As to finding Roman numeral 4, number 1, the audit committee finds that management did not breach its fiduciary duty with regard to special compensation payments identified in the audit report. Number 2, the audit committee recommends that management propose a policy for special compensation and present such policy to the board for approval. Number 3, the audit committee recommends that Sandag management propose an annual process for board approval of special compensation.
Okay, Paul, your turn to explain this. Keep in mind, Bill is not reading the text, so you know he's listening here.
All right. So the goal here again is to deal with the past and the future. And I'm the number 1 of 3, Bill Wells, deals with were these past challenge payments a breach of fiduciary duty? Having gone through all the documents as best I can and so on, I conclude not a breach of fiduciary duty, but recommendations 2 and 3 say step up your documentation process going forward. So the recommendation, I would propose the recommendation of the audit committee to the board is what happened was not well documented, but having gone through it is acceptable, but going forward, do a better job on documentation. That's it.
Okay. And Bill, I know you can't read this, so let me explain. In each of these sections, there's a finding and then there's a recommendation. So we're voting in on it together. If you don't like one piece of it, you can call it out. Like on the finding 2, you voted against recommending as a best practice past and future severance payments be supported by adequate documentation. So just try and, if you don't like one piece of it, pull the piece out. Don't keep in mind that there are other good pieces that go along with it. Go ahead. Go ahead, Bill. You go, and then I'll go to Bob. Go ahead, Bill.
Just to explain my discomfort with this, I'm just feeling like the board needs to see the auditor's recommendations. And
The board is going to see the auditor's recommendation, Bill, the whole thing. This is just a collateral document.
I understand that, Bill.
Well, I would support Bill.
Anyway, go on.
I support where Bill's going with this. I mean, it just strikes me that we're going beyond our duties as a committee to start making up our own recommendations. We're supposed to be speaking to the auditor's report, which is, I think, what Bill is saying.
This is matching the auditor's report. Sandy, would you want to clarify this? There seems to be some confusion here.
So the auditor's report has these individual findings, and the recommendations or the motion that Paul Dostart has put together address the findings and recommendations by the auditor. So they may not be point by point in terms of, for example, finding Roman numeral 4.1 might not match exactly this point 1, but it's addressing the issues that are raised in each finding and the audit committee's proposed response to those issues as proposed by Paul Dostart.
Okay, Bob, do you have any questions on this?
Well,
Go ahead.
this kind of goes back to the prior one, that I'm kind of looking at Mary's recommendations. And I want to make sure, like for instance, when we're talking about recommendation number 2, it says audit committee recommends that management propose a policy for special compensation. Mary has a couple of recommendations, require management to develop formalized procedures.
Wait, are you going back to 2, Bob?
No, I'm sorry.
We're done with 2.
I'm sorry. I'm on finding 4, but it's recommendation.
Okay, 4.2. 4.2.
Yeah,
Sorry, my mistake.
4.2. And I want to make sure I'm kind of understanding because and if I understood you right, Bill, Mary's report is going to go to the board for discussion to the board. Mary can be there to discuss this. And I want to make sure that the recommendations we're saying, these summarized recommendations, are they intended to include some of Mary's recommendations? For instance, like requiring management to develop formalized procedures for budgeting, reporting financial information. Is that something that we're kind of, this is more of a generalized recommendation?
Each group is different. Remember,
right.
This group can make whatever motion they want. They could have made the motion to approve as is or recommend as is Mary's recommendation, okay? Or it could add some collateral things. Why? Because we get to factor in our advice to the board what management said, and we also get to factor in what Art said.
Well, okay, all right. I think I'm ready to go.
On 4, okay.
And for one additional comment, Bill, I'm going to have to skip out after.
I know,
this one here. I'm sorry.
I can see that. And, okay, Bill, do you have any questions on 4? No? Okay,
No.
Okay. Let's call the roll on 4.
Thank you. From the City of La Mesa, Chair Baber.
Aye.
City of El Cajon, Mayor Wells.
No.
Public Member Paul Dostart.
Yes.
Public Member Stuart Halpern.
No.
And Public Member Robert Monson.
Yes.
Okay, so that passes 3-2. Bob, based on the trend, if you leave, nothing will get done, which maybe is a good thing. We'll see. Because Bill appears to be rolling no, and Stuart's a rolling no, and Bill and Paul are leaning rolling yes. So you tend to be the swing. So just keep that in mind. Just not to make you feel guilty, dude, but I am. Okay. As to finding 5, this is the adequacy of financial controls. The audit committee finds that Sandag management appropriately worked with outside consultants regarding the proper procedure for allocating bonuses and special compensation to projects during the audit period. Number 2, sorry, Sandy, I took your voiceover gig. The audit committee finds that Sandag Management did not improperly bill for bonuses paid to the former chief deputy executive director. Okay? Paul or Sandy, do you want to explain this one? No? Okay.
I'm fine.
Do you have any questions on this one, Mr. Monson? Okay, let's call the roll on this one.
Bill?
Bill, is that Bill Wells? Do you have a question? I'm sorry, Bill.
Yeah.
Go ahead.
Yeah, I do, Bill. Thank you. In regards to the improper payment, is this improper payment to whom?
Sandy?
I will hope to summarize the report in a way that is accurate. I believe that the audit report makes the assertion that there were improper billings to various contracts or entities in terms of how the compensation was billed out, because the compensation is allocated to different projects or entities. And so there was a concern raised in the audit report about whether the way it was billed out and the amount that was billed out was appropriate.
Okay, and what did management say?
Management's position was that that they have retained independent consultants to look at that over the years, and that it was billed in the same manner that has been previously approved.
Okay, and what was Mary's position, just to summarize?
That it was not appropriate.
Okay, understand the question, Bill?
Yeah, I do.
Okay, let's call the roll on this one.
Thank you. From the City of La Mesa, Chair Baber.
Aye.
City of El Cajon, Mayor Wells.
No.
Public Member Paul Dossart.
Yes.
Public Member Stuart Halpern.
No.
And Public Member Robert Monson.
Bob, did you leave? Okay,
like he
well,
left. I'll
then,
mark him
if
as
he
out.
left, that means 2-2, so the motion fails. Let's go to the next one, okay? As to finding 6, go ahead. I should let you do this voiceover, Sandy.
Oh.
As to finding Roman numeral 6,
Whoa.
Yeah, go ahead, you want it.
the audit committee does, oh, I'm sorry, it keeps popping off.
Okay, put it on the screen and
Trying.
then read it for Bill.
Okay. As to finding Roman numeral 6, the audit committee does not find any irregularities or gifts of public funds. Number 2, the audit committee recommends that Sandag Management present procedures for board approval consistent with OIPA's recommendations. Number 3, the audit committee recommends that management annually seek the board's approval of said compensation, maintaining adequate records to support such compensation.
Okay, hey, Paul, I have a suggestion. What if we just delete number 1 and see how they vote on the recommendations? Because let's eliminate the finding. Are you okay with changing the motion to eliminate the finding?
I was chuckling at my use of the phrase "said compensation." You can tell it was written by a lawyer. Could we vote on it twice if it doesn't pass with the finding?
No. All right, let's just vote on it once then. Okay, so it's on a finding that says there was no irregularity or gift of public funds, and recommendation that Sandag present procedures for board approval consistent with the OIPA recommendations. And the audit committee recommends that management annually seek the board's approval of said compensation, maintaining adequate records to support such compensation. So it's one finding that says there was not an illegal gift of public fund, one complete support of what management is, what OIPA is saying, and one that adds another provision to make the, another check and balance to encourage the board on this. So let's
Bill,
go.
I'll comment that 6.3 is, I'd say, kind of consistent in tone with OPA. In other words, I don't disagree with everything. It is kind of consistent with what they said. It's just
Okay.
what I proposed, the audit committee independent
Yeah.
recommendation.
All right, so let's
And
see
Bill,
how they
Bill,
vote.
just to be clear, Bill, you're saying it makes all three of those findings?
One's a finding, two's a recommendation. That's why I offered Paul to see if I could make it work easier to pull out number one. He didn't want to do it. So
yeah, because I could certainly vote for the recommendation.
All right.
Okay.
Well, Mr. Chair, may I alter my motion?
yes.
To
All
remove
right. And I'll second it. Okay. So we're going to pull number one out. Just wipe it off the screen, Sandy.
Okay.
Okay. So now it's just the two recommendations. Are you ready to vote on that? Okay. Call the roll.
Thank you. City of La Mesa, Chair Baber.
Aye.
City of El Cajon, Mayor Wells.
Yes.
Public Member Paul Dostart.
Yes.
Public Member Stuart Halpern.
No.
Okay. That motion passes 3-1. Okay. The next one. This should be easy, but we'll see. The Audit Committee, we can put up number 7. The Audit Committee recommends that Sandag Management present procedures for board approval consistent with OIPA's recommendations. Okay. Paul, do you want to say something? You can only screw it up if you talk.
I have no comment. It speaks for itself.
Okay. Let's call the roll. Aye.
Apologies.
My mic's on. There we go. Oh, somebody else's mic. Sorry.
Just for the record, that was an aye from Chair Baber. City of El Cajon, Mayor Wells.
Yes.
Public Member Paul Dostart.
Yes.
And Public Member Robert Monson is absent. I apologize. I skipped. Mr. Halpern?
Yes.
Okay, there's a
That
4-0. Okay, good. Okay, and just for the record, every time there's an absent, it's Monson's absent. Okay. Okay, item finding 8. Do you want to put this up on the screen and read it into the record, Sandy? And so Bill can hear it?
As to finding Roman numeral 8, number 1, the Audit Committee finds that the reorganization was performed for a legitimate public purpose. Number 2, the Audit Committee finds that the Executive Director appropriately exercised his authority in working with an outside consulting firm to design and implement the reorganization. Number 3, the Audit Committee recommends against reverting salaries, conducting a further needs assessment, or making any changes to those positions at this time.
Okay, Paul, do you want to explain that?
A little bit. The final audit report, as I understand it, it is highly critical of the reorganization, that this was not undertaken for a legitimate and proper purpose. And at various stages appears to have recommended, firing people or pulling them back to their old jobs when they're 11 and a half months into their job. And then, I don't remember if, I'll just say this based on personal knowledge. I can't remember if it was covered in a closed committee, which is why I'm not sure. But as a person, personally as a lawyer, when you go around and have given somebody a job and then you say, well, we've decided to demote you or something, you've got a whole different issue you got to deal with legally. My sense is the dust has settled here, and it's the reorganization was proper and normal. It was advised by an outside professional firm that does this. So I just recommend that we advise the Board of Directors as set forth in findings 8, 1, 2, and 3.
Okay, any questions from you, Bill? Okay, let's, there's
Sorry, I was
2
on mute.
findings and 1 recommendation, Bill, okay? The recommendation is against reverting salaries, conducting a further needs assessment, or making any changes to those positions at this time, i.e., we're not going to claw back those employees' decisions, or we don't, better way of saying it, we don't recommend that the board move to claw back those positions, okay? And then 1 and 2 are...
Can we vote on these separately, please?
Yeah. Or actually, you know something? Paul, Bill, do you want to vote yes, or if you want to vote on number 3 and just remove the findings, I'm okay with that too. Is that what your inference is?
That's fine. That would be my motion.
Okay, Paul, let's go back. Are you okay with removing the findings 1 and 2 and just voting on the recommendation?
Yeah, if that was an amendment to my motion, I accept it.
Okay, then I'll second that since I second the motion. So Sandy, just remove the findings. Okay, let's vote on just the recommendation, okay? And the recommendation on the table then, Bill, is the audit committee recommends against reverting salaries, conducting a further needs assessment, or making any changes to those positions at this time. Okay, call the roll.
Thank you. City of La Mesa, Chair Baber.
Yes?
City of El Cajon, Mayor Wells.
Yes.
Public Member Paul Dostart.
Yes.
Public Member Stuart Halpern.
No.
Okay.
And for the record, Mr. Monson is absent.
Okay, so that adjusted passes 3-1. The recommendation passed 3-1. The findings were removed. Okay, the next one is a finding with no recommendation. Okay, so Bill, listen to this. You may just want to kill the whole thing. The audit committee finds the executive director was within his authority in utilizing a non-competitive process for the positions at issue. Since Sandag is not subject to state civil service rules, the executive director acted in good faith and had at least apparent authority to promote from within Sandag without conducting an open recruitment. Do you want to summarize that, Sandy, that one paragraph? I mean, I said it, but explain in better terms than me, because there are no recommendations here.
And once again, I refer to the draft, or the final audit report for the actual wording used, but I believe that the audit report contended that the executive director should have used a competitive process for the positions that are at issue in finding Roman numeral 9. But the finding here by the audit committee is that a competitive process was not required because Sandag is not subject to the state civil service rules. And as management suggested, the employee handbook provides the executive director with discretion when to use a competitive process and when to use a non-competitive process.
Okay. Do you understand what the issue, Bill?
I do. And
okay, let's call.
It may be best policy. I'm just uncomfortable with challenging the auditor.
That's okay. No, look, everybody votes their conscience. It's okay. I'm just making the trains run on time here. Okay.
No. I appreciate.
Yeah.
Difficult.
That's fine. You can think about it. You're going to have, when it comes to the board, it'll come back again. So call the roll.
Thank you. City of La Mesa, Chair Baber.
Yes.
City of El Cajon, Mayor Wells.
No.
Public Member Paul Dostart.
Yes.
Public Member Stuart Halpern.
No.
And for the record, Mr. Monser.
Okay, so that motion fails 2-2, so that's not going to the board, okay? What's going wrong? Hold on, everybody, we're having a technical difficulty. What's going on? Okay.
Just the screen was not shared on that vote, and then we just shared it.
Okay, good.
Yeah.
Okay, the next one is number 10. We're getting to the finish line. Hang in there. This is what the at-will employees issue. So, Sandy, do you want to read into the record and put on the screen Paul's two draft items here? One is these are both findings. There's no recommendation. Okay.
As to finding Roman numeral 10, number 1, the audit committee does not find that the administrative rules and regulations are in effect. Thus, OIPA's recommendations should not be followed. Number 2, the audit committee further finds each employee's voluntary agreement to convert to at-will was appropriate. At-will employees continue to have protections from arbitrary actions under Sandag's employee handbook and related policies.
Okay. These are findings. Findings are having a difficult time getting through here, Paul. Do you want to pull them, or do you want to force a vote?
Well,
just reading the ground here, buddy. So up to you.
Well, you've got the let me just go back and see it. I would think should not be followed. I think that I don't know.
Okay, well, let's I'll tell you what, let's just go to the vote on it.
Yeah, let's have a vote.
Okay.
You
Call
know,
the
I
roll.
put a lot of hours into this thing, damn it. Let's vote on it.
Yeah, well, that's, you know, a great art is often left on the cutting room floor.
And may I just clarify something? I believe that the failed motions go to the board because every action taken here is going to go in front of the board. So even if it fails, the board will be aware that it failed.
Okay, so the board would know that failed 2-2 or something, right?
Yes.
Okay, fine. But the ones where he pulled it are not going to the board because it was never voted on.
Correct.
Okay. So, all right. So, here's your choices, Paul. Pull it and it dies here, or force it and it's probably going to go to the board as a 2-2. But
All right, let me pull the motion, please.
I'll second that. Okay. Bill or do you have any problem with us pulling it?
No.
Okay. All right, there we go. Now, that's the end of the recommendations that are linked to Mary's report. But we have other recommendations, okay? And these are 4 that come from Art's report, and they all harken back to the severance payments, the severance agreements, okay? Paul wrote these from Art's advice, our independent counsel, okay? So put up these 1, 2, 3, and 4, okay? They're up there. You want to read them to Bill?
Yes. Additionally, after considering the Rennie Public Law Group's advice, number 1, the Audit Committee recommends that the board instruct Sandag's General Counsel to determine and report to the board whether the executive director timely reported severance payments to the board.
Okay, let's stop and explain it. It's unclear, as far as we can tell, and Art mentioned this, whether the executive director timely reported the payments to the board. And Art recommended, and Paul embodied that argument in saying, the general counsel should go figure that out and report it to the board, okay? Get us an answer on that one. Number 2, go ahead, Sandy.
Number 2, the Audit Committee recommends that the board formally ratify the severance payments identified in the audit report.
And what's the explanation on that, Sandy?
The explanation on that is that the Rennie Public Law Group indicated that the severance payments, it seemed to indicate that the severance payments could still be ratified by the board even at this date.
And I'd say in simple terms, Bill, even if everything wasn't done properly to this point, a board can go back and ratify that regarding the severance payments to those employees, okay? So this is a recommendation that the board do that, meaning fix it by ratification, which is an acceptable way to do it under law. Okay, read numbers.
Can I comment just because
Sure.
Stuart and Bill won't know this. In Art's memo that we got on yesterday, on the last page, Art discusses a case called Western Oil, which is, I recall, a California Supreme Court case that says exactly what Chair Baber just said. So if there is a foot fault in the documentation, a board ratification with those prior actions cures the foot fault, and you're move forward and focus on the future rather than ruminating about foot faults in the past, and that's why this is here.
Okay. Number 3, the Audit Committee recommends that the board specify the procedure for setting and reporting severance payments in the future. What are we saying there? Hey, board, set a policy so your Audit Committee someday can determine if the policy is being followed. That's the way that's common man talk for it, okay? And then number 4 is, Paul, why don't you read, I'll read it, but Paul, you're going to have to explain it. The Audit Committee recommends that Sandag's General Counsel prepare an analysis for board consideration as to whether 1.5 of the employee handbook should be modified to require notification to board leadership in specific circumstances. Why should we recommend to the board that this part of the employee handbook be modified, Paul?
This, once again, comes right out of Art's very scholarly and readable opinion that we received yesterday. And he says, employee handbook, this is where I asked the question, if you assumed all the right corporate formalities were there so that I understand the legal issue, is this level of delegation legal under law? Art does an analysis and says, yes, it is. The only gray area is whether there is a sufficient constraint on the executive director. On balance, Art finds there is a sufficient constraint, but as Paul Dostart read it, I said, well, let's get rid of even the gray area and just have general counsel prepare an analysis and give it to the board about should section 1.5, which is where this constraint would be beefed up if it is, should be beefed up. So this is to make improvements.
So, Bill, if you're open to any of these four, but not others, I will call to divide the questions so we can separate them out. Or are you open to?
Number 3 sounds reasonable to me.
Okay, then let's.
I've got two questions.
I have a question.
Who said that?
This is Bill.
Go ahead.
We're kind of talking apples and oranges. I mean, we're dealing with an attorney who's got a different set of guidelines than an auditor. So I'm not sure why we're not recommending what the auditor has to say in this case. I mean, whether or not the board accepts it or not is a different story.
Well, for example, number 2, the audit committee recommends that the board formally ratify the severance payments identified in the audit report. That is a legal way of solving the entire question, right? Because whether they were properly done can be fixed by a board ratification. So these are suggestions, okay? So let's divide the question and do number 1. The audit committee recommends that the board instructs Sandag's general counsel to determine and report to the board whether the executive director timely reported severance payments to the board. Okay, so let's call that question.
Relating to that one?
Who's Bill? Are you saying something? I can't see your face. Stuart, go ahead.
Just two questions. First, isn't that one of the things that the auditor's report recommends be done by a board-hired independent voice, part one? And even if I've got that wrong, secondly, could somebody just confirm, does the Sandag General Counsel report to the board or to the executive director?
Sandy? Julie, are you still there? Or Amber Lynn? I see Amber Lynn's face. Go ahead, Amber Lynn.
Thank you. Formally, the Office of General Counsel reports to the board, as that is where the attorney-client relationship lies. There is also a line reporting to the executive director.
Okay. And the inference there that you want it reported, you want it determined, but you want it to be determined by someone else, Stuart?
Well, no, I was just asking the question and maybe I'm not remembering correctly as to whether the auditor's report suggests that in item 1 that be done by external counsel, because I believe she called into question sort of the independence, if you will, of the general counsel relating to certain.
Mary, if I can ask you on that, is that what you recommended?
Currently, the general counsel reports a dotted line. The general counsel currently, according to the organizational chart, reports a dotted line to the board, a solid line, functional solid line to the executive director. And yes, for that reason, it was recommended that an independent counsel for the board be involved in all this.
Okay. Well, we're probably locked up on who's going to do the work. Would either of you, Bill, accept if we amended it to say the audit committee recommends that the board determine and whether the executive director timely reported severance payments to the board, and just leave it up to the board as to who does the work?
Yes, please.
Okay. Paul, are you okay with that?
Yeah, that's a fine amendment.
Okay. All right. The audit committee recommends that the board, and I'm deleting this, Sandy, keep the word determine.
She's got it, Bill, on the screen.
I got it. You're way faster than me, Sandy. Okay, let's vote on that. Call the roll.
Thank you. City of La Mesa, Chair Baber.
Aye.
City of El Cajon, Mayor Wells.
Yes.
Public Member Paul Dostart.
Yes.
Public Member Stuart Halpern.
Yes.
Okay, so
And
that,
Mr. Monson is absent. That passes unanimously.
4-0. Okay, second sub here. The audit committee recommends that the board formally ratify the severance payments identified in the audit report. This is a legal fix. Reasonable minds can differ whether you want the board to ratify this or not. So, if there's no questions, let's just call the roll.
City of La Mesa, Chair Baber.
Aye.
City of El Cajon, Mayor Wells.
No.
Public Member Paul Dustart.
Yes.
Public Member Stuart Halpern.
No.
Okay, so that motion fails 2-2, but apparently will be reported as a 2-2 vote. Okay. Sub-item 3, the audit committee recommends that the board specify the procedure for setting and reporting severance payments in the future. Okay? I think this might be something everybody agrees on. So let's call the roll and see if I'm lucky.
City of La Mesa, Chair Baber.
Aye.
City of El Cajon, Mayor Wells.
Did we lose Bill?
Sorry,
or is that
yes.
a no? That's a yes.
Yes.
Okay.
Public Member Paul Dustart.
Yes.
Public Member Stuart Halpern.
Yes.
And Mr. Monson is absent.
All right, so that moves forward 4-0. The final one is Paul's. The audit committee recommends that Sandag's general counsel prepare an analysis for board consideration as to 1.5 of the employee handbook should be modified to require notification to board leadership in specific circumstances. That's a very narrow request, Paul. Do you want to explain that to the rest of us?
No, that's the one that came right out of Art's report. This is the one about
Okay.
delegations are appropriate if there are appropriate limitations. Art concludes it's gray, but on balance, yes, there are sufficient limitations. I want to beef it up and have either general counsel, or if they're going to hire an outside, how about if we just take out the general counsel and the Sandag board secure an analysis rather than general counsel prepare, and then that might make it get 4 votes.
Fine with me. We'll consider that an
Should we-
amendment we'll amend it. Okay. So now it reads, Bill.
Under discussion, Chairman?
Who said
Under
that?
discussion, Chairman, should we change that to reflect that the board should discuss it and come up with an appropriate fix?
The audit committee recommends that Sandag's board discuss
Discuss this issue.
whether 1.5 of the employee handbook should be modified to require notification to board leadership in defined circumstances. Okay. Is that all right? Did you pick up on that, Sandy? Are you okay with that, Paul?
I think it makes it a worse motion. I think secure an analysis for the board to consider is better than the board hauling off and discuss it without any.
I don't know. A motion that passes is usually better than one that fails, Paul. But that's just me.
I see what Paul's saying, and I don't disagree with him, but I think I don't want to get into the position where we're taking away the auditor's responsibility unless there's something egregious that's occurred.
All right, well, I'll defer to Bill Wells' modification of my motion.
All right.
I would agree
Okay.
with Bill on this, and if I could just ask if Mary could chime in, did she specifically recommend that, in fact, that there should be notification, so that by our item 4 here is in effect sort of changing Mary's recommendation?
You want to answer that, Mary?
You know, Stuart, that's really hard to answer because none of these actually are my recommendations, and a lot of them are findings that aren't even my findings, and really the board or the audit committee taking on the role, and this attorney taking on the role as an auditor, and from that making auditing decisions. I mean,
Okay, now you're filibustering, but how long do you need?
excuse me, I think that's really inappropriate. But what I was trying to say, Stuart, was that a lot of these things I have issues with because they're not auditors' recommendations, and they're not my findings for that matter. They've been changed and again manipulated, and that's concerning for me. So it's hard for me to answer that question, Stuart.
Okay.
At no time, Stuart, did we represent these were Mary's findings. We said that at the beginning. So, all right, do you want to comment on this?
No, I have no.
Okay. Okay, let's call a roll on this one then. On the revised one, it says, the audit committee recommends that Sandag's board discuss whether section 1.5 of the employee handbook should be modified to require notification to board leadership in defined circumstances.
City of La Mesa, Chair Baber.
Aye.
City of El Cajon, Mayor Wells.
Yes.
Public Member Paul Dostart.
Yes.
Public Member Stuart Halpern.
I would vote yes on this one.
Okay.
And Mr. Monson is absent.
All right, so that passes. So we only have one more, okay? This came from me, and if you voted down, I'm good, because I'm protected if you voted down. But the audit committee recommends that the OIPA, the board, the audit committee, or any Sandag employee generally not release to the public any document that identifies any Sandag employee by name and/or unique title whose personnel records are discussed without first redacting the names of that employee and/or unique title to protect that employee's privacy. Bill, this came from what was going to be published under my authority. Legal counsel said these are employees with sensitive personnel records that are being put in question. These are also other employees that have not NDAs. And if you publish them, you're exposed for it. And I said, no, not doing that. Mary shows the other path, doesn't believe there's an exposure, and published it. So we recommend that nobody publish it. But reasonable minds can differ, obviously, because management and Mary differ on it. So you have a question on that, Bill?
Well, certainly in running my business, that's exactly how I would do it. And I think that we should always keep people's names and titles out of things. However, I'm worried about overstepping my bounds with a future auditor or this auditor. So I'd like to encourage the board to discuss it and come up with a plan.
Yeah, it'll be too late by the time they discuss it because the act will already have been published. But I take it, Sandy, when these go to the full board, is management going to change its redacting policy?
I don't have any indication one way or the other.
And it's not my problem when it goes to the full board because it's Chairman Boss is going to have to make the call?
Well, then can I make...
That's why I'm voting for this, okay.
Propose a motion in that regard?
Go ahead. You can try it. Go ahead, Stuart.
I would propose the motion that there be no redaction of an independent auditor's report without prior consultation with the independent auditor.
I don't know what that means, meaning it's consultation but not approval?
Well, I guess the spirit of it would be that if there is disagreement, that it then be brought to the committee, perhaps in closed session, but that there should not be unilateral redaction. Well, look, Stuart, the horse is out of the barn. It's already been published by the OIPA and it's on the website. But your proposal speaks to the future, and so similarly, I'm trying to get us on the same page as to what future conduct should be. Okay, I guess that's a motion. Is that a second? Okay, hearing none.
I'll second this motion.
Okay, let's have an up or down vote on that motion. We'll consider this functionally a substitute motion of the main motion. Okay, call the roll on the substitute motion.
On the substitute motion, City of La Mesa, Chair Baber.
No.
City of El Cajon, Mayor Wells.
Yes.
Public Member Paul Dostart.
I'm going to have the motion read again. It changed too quickly in me at the end. So go ahead.
All right. Did you put it up on the screen, Sandy? Read it. It should be on the screen, Paul.
Right now, the voting is on the screen.
Can
So
you-
the motion is there should be no redaction of an independent auditor's report without prior consultation with the independent auditor.
Okay, and it doesn't call for approval, just consultation. And would Stuart, you made the motion, would that also then obligate the independent auditor to not release a report with names unless the audit committee has had an opportunity to review and consult.
I would suggest that that could be a separate motion, but I just feel it's important that both in practice and for the world to know that we're not in the business of altering an independent auditor's report without discussing with them first. I would characterize that as the integrity of our committee and the office.
Yeah. And I would argue, Stuart, respectfully, we're also not in the business of violating NDAs that have been signed by the organization.
That could be a separate point. All I'm saying is there should at least be prior consultation.
Okay, let's have okay, Paul, you interrupted the motion. It's a 1-1 vote so far. Go ahead.
I'm going to vote no with the idea that I'd like to come back and put the two together. So
okay, Stuart, your vote.
Yes.
Okay, so that motion fails. So we're back to the main motion, okay? And the main motion is that the audit committee recommends that the OIPA, the board, the audit committee, or any Sandag employee generally not release to the public any document that identifies any Sandag employee by name and or unique title whose personnel records are discussed without first redacting the names of that employee and or unique title to protect the employee's privacy. We can vote on that. It'll probably come up 2-2, and then there'll be no decision coming out of their functional. Unless anybody wants to, fix it to get a third vote, let's just roll with that. And guess what? This is the last one, folks. So as long as you stick on this, this is how long we're going to stay today.
City of La Mesa, Chair Baber.
Yes.
City of El Cajon, Mayor Wells.
No.
Public Member Paul Dostart.
I'll join Wells on this one.
Okay.
I'll say no. No.
And Public Member Stuart Halpern.
No.
Okay, well then it fails, so no action on this item. That's the end of the prepared motions. However, Bill, Stuart, Paul, you can add whatever you want at this time.
No, I'm good.
Okay, well, hearing that, that ends item 2. Upcoming meetings, the next audit committee is tentatively scheduled for Friday, September 25th. I'm not sure we're going to have that meeting. Depends on a lot of things. First of all, we did a lot of work tonight, so I'm going to have to consult with staff and my liaison and Mary as to what needs to be done on that meeting. So as of right now, it's scheduled, but I'm telling you, it may not be because we had this special meeting. Without any other further action, let's adjourn the meeting, right?
Thank you.
Okay, thanks everybody for participating. Bye-bye.